Mention item number 15, Lordship. In this case, Lordship, we are on interim, Lordship. We have been instructed that charge sheet has been submitted, Lordship. Yes, charge sheet.
Number.
The CS number 107/25, dated 31/5/25.
Are you are interim? No?
Yes, Lordship.
So interim will be extended up to 15 days.
Yes.
Okay.
Highly obliged.
May I plead the Lordship?
Keep that part.
Lordship, I am back to mention one item, Lordship. It was last listed on 18/7 before your Lordship. It was ordered to be listed before the appropriate bench. Appropriate bench was not sitting, now it is sitting, Lordship. It may kindly be listed for bail hearing, Lordship. Before court number 13.
Special matter.
Special matter.
Then you have to make a mention before court number. Very.
Court number 13.
Special bench.
No, Lordship, not special matter.
No. Special bench for lawyer.
I was told that this is the bail hearing senior bench, Lordship. I approached before the court number 6.
Asking you, matter is a special matter.
No, Lordship.
It's a special case.
No, Lordship.
Under which act? BNS.
BNS.
Okay. Okay.
BNS.
Okay.
Deeply obliged.
It will be listed
During this week.
During this week. Okay.
Deeply obliged.
Please, your Lordship, I beg to mention item number 8, Lordship. Perhaps CD not received, Lordship.
Yes,
Next week, Lord.
city not received. It should remind. Yes. Pardon? 29 will do.
Today is almost 40 days, Lordship.
40.
Yes. Finally.
29.
May I plead the Lordship, I beg to mention for listing a matter for withdrawal of petition, your Lordship. In this, it is a BA application, your Lordship, and tomorrow. Okay. Highly obliged, your Lordship.
May it please your Lordship, I am praying for listing of 2 IA, my Lord. IA pertains to, my Lord, modification of one of the bail condition passed earlier in BA 207127. Day after tomorrow, my Lord, on Wednesday.
May please your Lordship. Also, I beg to mention a fresh bail application, Lordship. Even tomorrow, Lordship.
Maybe 5. May not. 22nd.
Uh,
22nd.
There's some urgency, my lord. Let it be on 20, my lord, on Wednesday, my lord.
Okay.
Obliged.
May I please to mention, Lordship, I'm here for item number 28 from the daily list. The CD was called for, Lordship. Accused number 2 is on interim.
CD not received. You are on interim? You are on interim?
Accused number 2 is on interim.
2/8.
28.
Item number 28.
28.
So what we're saying 2?
Petitioner number 2 is on interim.
1 is not on interim. Only 2.
Yes.
Interim for the petition number 2 may be extended. Be extended to the next of this.
Lordship, a short date
Issue
might be
reminder.
given.
Just accordingly. No, we don't have any such short date. Yes.
28.
28.
Obliged, ma'am. May I please, your Lordship. Lordship, I beg to mention item number 5, Lordship. Lordship, I may be allowed to withdraw, Lordship.
Item number 5.
Yes, Lordship.
Want to withdraw this?
Yes, Lordship.
As per instructions of your client?
Yes, Lordship.
Withdraw. Okay.
Deeply obliged.
May I please, Lordship, I beg to mention for listing IA criminal serial number 7232. Tomorrow, your lordship.
No,
It is succeeded case and the next date is 22, your lordship. Next date is 22 in the lower court, your lordship.
why I want to file
I have for rectification order dated 17/7/2025, your lordship.
for rectification.
Your lord.
21.
AB 94/2025.
20.
Obliged, your lordship.
May I please your lordship? Lordship, this is a regular bail application, my lord. I am behind bars for 34 days, lordship. The instant case, my lord, is of purely civil nature, my lord. The incident has arises out of a civil dispute, my lord. Your lordship, kindly come to page 14, my lord, the translated portion of the FIR, my lord.
Mm.
I read, your lordship.
But here is a allegation of you attack.
109
some
is not
sharp
not against the present petitioner, my lord. That was added later, my lord. In the forwarding, 109 is not against me, my lord. The forwarding is of
No. I'm not on that. I'm just on FIR.
yes, lord.
FIR doesn't speak that it is a civil nature of case
Yes, your lord.
because it is we have. I mean, the allegation is that you attack with some sharp weapon.
The
That's
allegation,
the allegation. That
al-
is not the civil dispute.
lordship,
No, you're saying
allegation
the
is
civil
there, my
dispute.
lord. If your lordship sees the last paragraph of the FIR, my lord, here,
Yes, a civil proceeding is there.
yes,
But out of that civil proceeding, the case is not there. Anyway, we were in custody since
34 days, my lord.
34 days. Yes, what happened?
Rejected twice by the trial court.
Earlier rejected twice by the trial court.
Page 23 and 23, from 12/25, 7/25 to the 12/8/25.
In the meantime, my lord, all the co-accused were given, my lord, interim pre-arrest bail by this honorable court, my lord. I have annexed the order. Lordship, that is
Maybe, I don't know.
page 73, page
Whatever,
69.
your petition is in custody now, so we have to page
Page 69, my lord.
60,
9.
69. Okay, when it can be called.
Lordship, the AB is fixed on 19 tomorrow, my lord. The anticipatory bail application, my lord, 1681 is fixed tomorrow, my lord.
AB is on 19, believe. But okay, the 19 is fixed.
19. Sorry.
Please, your lordship. My lord, from the same FIR, another case, item number 21 is there, lordship.
21.
And I am told that CD is here, but I may be taken with that item, lordship.
CD is available.
Yes, lordship, as I am informed, lordship. 21,
21.
yes,
Okay, then we'll take it again.
lordship.
May it please your lordship, this is an application under 482, your lordship, anticipatory bail. Your lordship will finally see the FIR at page 12. And the written FIR is at page 15.
Yes.
Here, your lordship, what has happened? The sections that has been incorporated in this basically 61 to 140, 117, 274, 76, and 308. Your lordship, out of these sections, mainly, your lordship, the allegation was with regard to the four persons went there to the house of one person to get recovered the lady. So there was no such grievous hurt or something. There was only that the lady was recovered, brought to a particular club, that A ABMSU club, and there she was brought. And then there was one allegation which was not very strong, not with against specifically against the present petitioners, is that she was asked to disrobe to find out whether undergarments were there or not. That part is the only very something which is not specific against this person. And other than that, your lordship, rest is two persons who were their relatives. Actually, they brought the girl to that particular club, and from the club they were brought home. She was brought. She was not kidnapped. Even kidnapping charges and murder charges were there. These are not there. Only thing, that is the only part, your lordship. In this case, your lordship, they were, some of the accused are named. That is Nasir, Amjad, Izabul. Two Izabuls are there and one Tayabar. They were the named person, your lordship. Here, your lordship, in the Amjad Ali Khan, the first petitioner is not even named in the FIR, your lordship. The other two has been named, but your lordship, there are two persons with the same name. The other person with the same name has already been granted interim protection by this honorable court. That your lordship can find at page 18, 118. His name is same, but they are two different persons. And here, your lordship, this he has already been granted interim by this. So, your lordship, in this case, first petitioner number 1 was not even named. 2 has been named. 3 is now, your lordship. Which one is the one we don't know? This was actually a club, your lordship. There were many persons were there. Some went to the house of the with the where the girl was found, and then she was brought along with that person to that club, and then in fact they were requested to go to the police, but she later on filed a FIR, and on the basis of the FIR, your lordship, some persons were
All
named.
these three names are there in the FIR. You are the
Yes.
named.
Now the only, your lordship, the name of Taibur is seen here.
Taibur, Jabul, everyone is there.
Taibur is Toibar is written, but I think its name is Taibur. I think that
Jabul is also there.
Izabul, your lordship, has already been granted bail by this honorable court. And this is another Izabul, your lordship, who was also present in the club. So now, your lordship,
No,
except
but that Ijabul and your Ijabul is also there. Amdal is also there in the FIR. It's not a case that your name is not there. Everyone
no,
is named
that's
in
the, your lordship, Izabul name, your lordship, is seen to be.
Izabul is named, Amzad is also named, Toibur is named, everyone, all three are there.
Yes, and others are also there. So, and in fact, one Izabul has already been granted bail. I don't know, because the name are same in both the cases.
Yes, Potter.
From the Contradictory FIR, it feels that television are they not only inappropriately charge the victim, also ask whether they regarding those allegations. Specifically, allegation is against that he is the leader of the killing was released by Nasir Ramzad, and specific allegation before that also against Bayabur and Izabul.
I don't think that it's a case of interim. Let us peruse the case diary. Your involvement, we have to see. Yes, when it can be called for what?
20
20? 20 will get decided and it's okay.
No, 28.
28. Okay.
26.
26. Okay, we call.
Look.
May I please, your lordship? Lordship 482 BNSS application, your lordship. And the FI is at page number, particular question at page number 9, your lordship. Okay, the allegation is that one bull has been taken away from his cow shed, your lordship. Otherwise, no vehicle has been mentioned in the FIR, your lordship. No name accused, your lordship, as for the FIR.
So why you are apprehending?
Yes, your lordship. Because if your lordship kindly see the seizure list, your lordship, at page number 12, your lordship. My vehicle has been suspected, your lordship. It is still, your lordship, lying in the police station, your lordship. And the case has been registered under section 302, subsection 3 of the.
Cattle was carrying in that vehicle, in your ways.
It was not in the FIR, Your Lordship, but it was suspected to be like that, Your Lordship. Because for that reason only, Your Lordship, my vehicle has been seized, Your Lordship. Otherwise, if Your Lordship kindly see, he's the owner of the vehicle, Your Lordship. Otherwise, if Your Lordship kindly with due respect see, Lordship 3023, Your Lordship, it is a offense, Your Lordship, where the punishment can be, maximum punishment is 3 years, Your Lordship. So, Your Lordship, it is a fit case where, Lordship, the police can issue 41 in notice also, Your Lordship.
You have not received any?
No, Lordship. Nothing, Your Lordship.
Yes, what?
Two kettles were also recovered from that vehicle. Whether that only there or not recovered.
Hmm. Yeah, obviously, FIR, there is no any other statement regarding the recovery of this
Yes.
cattle from the vehicle, and not because he found that this cattle was missing.
Yes.
That much only.
Whether that
much.
vehicle might not related to the present case or not. The present
Now, you are saying that you are the owner.
Owner. Owner of the vehicle, my
But
vehicle is.
the cattle was recovered from this vehicle.
Yes. Two cattle without page 11, my lord.
Spread.
Two
Manipulated.
cattle without taking inside the vehicle. But here, my lord, FIR allegation is one whole.
Okay, let's see.
One red foot. Whether that is specifically, my lord, that red foot or not.
That is one thing. I heard Ms. Bora, the learned consultative petition, and also heard Mr. P. Vortaku, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Ms. Bora that the present petitioner is innocent and he is no way connected in the arrest office. He is apprehending arrest because his the vehicle has been seized by police. Which, sorry, the submitted that the present petitioner is the owner of the vehicle which has already been seized by police in connection with this case. And for that reason only, he has the apprehension of being arrested, of arrest in connection with this case. However, the present petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of interim pre-arrest bail. Next, Mr. Waterford submitted that there is no statement regarding the recovery of the cattle but from the seizure list which has been annexed along with the petition. It is seen that the recovery of the cattle was from the vehicle which has already been seized. In view of this, is submitted that the result of this CD may be required to know the actual factor. Swens. Considering this submission made by Swens. Okay, will be under interim protection.
No, sure.
When it can be fixed.
On 19th of September.
Pardon?
19
1 September.
September.
Much of this motion.
1
Lordship, this is a regular bail application, so this court is still yet awaited. POCSO matter.
Service report awaited.
Services awaited. No? Your MSP Bora, no?
Yes, Lordship.
Our MSP Bora, the petitioner also heard Mr. P. Bortaku, Delaney, PP, responded. From the office note dated 13/8/2025, it is seen that the service is still awaited for the response number, though the scan copy has already been received. In that context, Mr. Bortaku, Delaney, Edition PP is hereby asked to take instructions in regard to the service of notice on the response. list the matter accordingly when it can be listed, what are
From
the state
second of-
instruction regarding.
Yes, 2/9.
Resolution.
7, 9, 13 and 29. मतलब 20 cases.
7, 7,
7, 9, 13 and 29.
13 and 29. All are connected.
FIR page 21.
You are appearing on 7.
7.
7 you are appearing.
Yes.
And on page
What is the position? You have, it is, it was
Suicide note to-
for the case diary or what? Case diary you have received here?
Yes, well, can I repeat?
Can I see the suicide note, Milo?
I don't know. Yes, Botako, can it be?
Put down.
No, no, is it? No, no, I can see. Mr. Bhattacharya submits in a, is it permissible or not? That's what. Is it permissible? Yes,
ऐसे अपना सवाल लिखेंगे।
क्यों?
Open case है।
Suicide note is only contents of the case diary. Case diary after investigation. This is much better. How do I make my defense? If it doesn't make out at all,
yes.
so we are in the High Court. These things are very preliminary. Oh, he didn't. May I read it, Your Lordship?
No, you submit subsequently. You just give submit first, your submission. You have received the case there, just for your submission, you made your submission. You are Aminul Islam. So you are,
Well,
who are you? In fact, you are a contractor, engineer or what?
engineer, my lord.
You are
I-
engineer.
Yes, I was transferred much before that. After about 21 days, she committed suicide.
So you got transfer, your transfer is
Transferred to Guwahati on 20th.
I was transferred on 24/6 and I joined on 7/7.
transferred on 24/6.
Yes, my lord. My notification is at page 14, 14.
And you join on
7/7, 2025. And incident is of 22/7, 2025.
incident is on
22/7, 2025. FIR is of 23/7, 2020.
Your Lordship has to see the proximity. For so many days,
you will see.
and these things are already, my lord, settled by the Supreme Court.
Your this transfer order you have annexed it.
My lord, page 14, 14.
1/4.
This is a government notification. Relevant portion is at page 15.
Say admit it. It's okay.
First one,
15. No problem with it. This suicide note says Moi Kaku blamed the Thoka Nai, but consultant should have been more responsible.
We'll see.
And first, she starts it by saying, I'm taking this step due to extreme stress from my work. I am lost there and there is no one to guide me in office.
so he has said the cause. I have no role to play there. Moreover, your Lordship has to see the proximity between the decision Supreme Court. (2023) SCC online 1598 para 10. In the present case, taking the complaint of the third respondent and the contents of the suicide note as correct, it is impossible to conclude that the appellants instigated the deceased to commit suicide by demanding the payment of the amount borrowed by the
third respondent from her husband by using abusive language and by assaulting him by a belt for that purpose. The said incident allegedly happened more than 2 weeks before the death of suicide. There is no allegation that any act was done by the appellant in the close proximity to the date of suicide. By no stretch of imagination, the alleged acts of the appellants can amount to instigate to commit suicide. The deceased has blamed the third respondent for landing trouble due to the bad habit. So context is proximity.
25.
Para 25. There it says what the abatement means. Abatement involves a mental process of instigating a person or intentionally aiding a person in doing of a thing without positive act on the part of the accused to instigate or aid in the committing suicide. Conviction cannot be sustained. The intention of the legislature and the ratio of the cases decided by this court is clear that in order to convict a person under section 306 IPC earlier one, there has to be a clear mens rea to commit the offense. It also requires an active act or direct act which led the deceased to commit suicide, seeing no option, and that act must have been intended to push the deceased into such a position that he committed suicide. In the instant case, the deceased was undoubtedly hypersensitive to ordinary petulant, discord, and difference, which happen in our day-to-day human life. Human sensitivity of each individual differs from the other. Different people behave differently and in the same situation. So, below there must be direct act committed by the accused, which persuaded the accused to commit suicide. And I am already 28 days in this. They are gazetted officers.
Who is appearing on 9? 9 who is appearing? You are appearing on
Yes, mine.
9.
Well, very unfortunate happening, my lord. That should not have happened, my lord. With all respect, my lord. The suicide note, of course, has been raised out, my lord. The designer, my lord, but that's a different matter altogether, my lord. Can I come to the FIR, my lord? What are the allegations, my lord? I'll be very, very cryptic, my lord. Lordship, but kindly have a look, with all respect and folded hands, my lord, at FIR is at, my lord, page 22. Page,
Yes.
with all respect, my lord, Lordship has found the allegations are primarily, my lord, work pressure, and that, my lord, with all respect, my lord, so many 3 persons are specifically named, and on the date of lodging the FIR itself, my lord, all 3 officials, 1 executive engineer and 1 SDO, my lord, and possibly, my lord, the designer, some allegation, my lord, maybe may not be, my lord, in the suicide note, my lord. Designer, he has also been arrested.
You are, who are you?
I am the executive engineer, my lord. Executive engineer, my lord. And my lord, I'll come to that, my lord. That my role is, my lord, entire district, my lord, several subdivisions. That I'll come, my lord. The allegations in the FIR itself, my lord, may not constitute earlier, my lord, with all respect, my lord, 306 and now 108, my lord, apparent on face of the record, my lord. I'll not read the whole FIR, my lord, give it too lengthy, my lord. Only the relevant part. First paragraph, my lord. Last lines, my lord. She was forced because the FIR has been lodged by the deceased sister, my lord. The paramount points, my lord. She was forced, coerced, this is the language, my lord, criminally intimated and threatened to prepare and passed estimate and bills in irregular manner, which took a severe toll on her, for which she had to take this extreme step and thereby putting an end to her life. This is after receiving the suicide note, my lord. And suicide note, that part, in a court order also, it has been exhibited, my lord. English to Diana. Yes, I'm taking a minute, my lord. In English, it is there. I'm not reading from the suicide note, my lord. This is an order of the court, my lord. Again, I am taking this extreme step. My lord, this is an order. Chief Judicial Magistrate Bongaigaon, my lord. I'm not reading from the suicide note, my lord. The suicide note itself said, I'm not taking this step due to extreme stress from my work. And I'm lost and there is no one to guide me in office. I was assigned the project mini stadium at Boshongao, whatever be it, my lord, under Bongaigaon LSC and the consultant MS, consultant, my lord. Have I made my position clear, my lord? Consultant, aesthetic creation owner owner architect Devojit Sharma presented a hopeless estimate which had major discrepancies and variations. Variations. During examination, no. This is a sorry, I'm taking a minute, my lord. My lord, if I read it in totality also, definitely, my lord, stress was there. Very unfortunate, it should not have happened. Possibly the architect is also not, he made a design, my lord, as per the suicide note, as sir has read out, my lord, that the estimates were not in accordance with the realities, my lord. So, as being the assistant engineer being entrusted with the job, she exceeded the estimate, my lord. That is there in the suicide note. That is the main cause, my lord. Have I made my question clear, my lord?
She exceeded the
Estimate provided by the, can I read in SMIS, my lord? That from the suicide note?
She exceeded.
It is there in the suicide note, my lord. An observation of the CGM. If I read it, I can place it before your lords. My lord, can I just read it, my lord? No, you can read it. Suicide note to continue. I'm taking a minute, my lord. Lordship will not take it otherwise. I just have there. No, it is a poor sir. I was trying my best, but I was, my lord, this is the language, my lord. I'm reading part of it, my lord, to present a working estimate, which was very unknown to me. My superior SDO Aminul Islam E. Dinesh Sharma made me continue the project on my own despite me asking for help. Proper architect drawing were not provided and I had to prepare the working estimate based on whatever drawing given to me. How I had come to a point where I am to submit the working estimate when the project is 66% completed. Have I made my position clear, my lord? And thereafter, that part of the suicide note, my lord, it shows, কোনখিনি দেখাই দিয়া নাহে ভাইটি মই এতিয়াহে পাইছো এখন কোনখিনি নহয় না তাৰ আগৰখিনি পঢ়া and I am unable to live with myself. Let me try to পঢ়ি দিওঁ. Unable to, I'm reading the whole, with all respect and tolerance, my lord. I am unable to live with myself this constant stress. I am having panic attacks and I am barely functioning. I am sorry, ma deuta, ata ma, so and so, my lord. Moi ki don't know, my lord. That's like a lot of grief, my lord. Thereafter, my lord, one line is there, my lord, that but consultants should have been more responsible. While preparing, I don't know, my lord, what she meant, but very unfortunate, my lord. He do,
সি এটা ভুল
estimate dia,
দিয়াত ভাবত
dia babot,
মই
এনেকে
ইমান কষ্ট
কৰিলো
খালো
সি দিয়া কষ্ট খালো সি দিয়া এমাউণ্টটো এক্সিড হৈ যায় প্ৰজেক্ট কমপ্লিট নহয়গে এই লাইন দিছ ইজ ভেৰি ইম্পৰ্টেণ্ট মাই লৰ্ড সি দিয়া এমাউণ্ট মানে নট ব্ৰাইব মাই লৰ্ড এষ্টিমেটেড এমাউণ্ট মাই লৰ্ড সি দিয়া এমাউণ্টটো এক্সিড হৈ যায় প্ৰজেক্ট কমপ্লিট নহয় বিকজ হি ৱাজ দ্য ইনচাৰ্জ মাই লৰ্ড কমপ্লিট নহয় মই চবৰে হাতত চবৰে কথা ভাবিব লাগে বাট মোৰ কথা কোনেও নাভাবে মোৰ কষ্ট মাই লৰ্ড কষ্ট কোনেও নাভাবে মই এইটো ষ্টেপ লৈ মই মুক্তি পাম মই বহুত বস্তু বুজিয়ে নাপাওঁ বাট মোক শিকাই দিয়া মানুহ নাই Have I made my position clear, my lord? My lord, this is whatever be it, my lord, very unfortunate, it should not have happened, my lord. But anyway, my lord, let me come to the FIR now, my lord. With all respect, I'll be very cryptic, my lord. Here it is written, my lord, family members. Upon hearing from the lady prior to her death, my lord, with all respect, my lord, whatever is there in the FIR, my lord. Architect Debojit Sharma, message aesthetic creation, SDO Aminul Islam, executive Dinesh Mary Sharma, regarding some ministerial project. She was forced, coerced, criminally intimidated, and threatened to prepare and pass estimate and bills in irregular manner, which took a severe toll on her, for which she had to take the extreme step and thereby putting an end to her life. This is one part, my lord. If it comes within the ambit of present 45, my lord, and with all respect, my lord, section 108, my lord, first there has to be abetment, then, my lord, that part, my lord, the abetment in commission of suicide, my lord. Then first page, my lord, second line, allegation against us, my lord. She further disclosed before us that our seniors, colleagues, contractors were asking her to do some work which are against the work policy of the department. When she objected and fails to do the same, they asked them to leave her job and or ridicule her being incompetent in her work. When she disclosed the undue work pressure she had faced to her seniors, they here the seniors, my lord, inclusive of me, my lord, they also did not help her. Better rebuke her and ask her to do the work as per their wish and also harass her mentally. Have I made my position clear, my lord? On these three allegations, FIR is lost, and thereafter, my lord, kindly see, lordship knows more than me, my lord, because this abetment in commission of suicide, my lord, if somebody abets also, my lord, meaning thereby fulfilling all the ingredients of section 45, earlier 107, my lord, intentionally aids, abets, all those, I'll read that out, my lord, with all respect, my lord. Even then it has to be proximate, my lord. Have I made my position clear, my lord? Kindly see one part of the forward I'll be very cryptic, my lord, to bring the forwarding report, my lord, of the arrested accused persons. There, my lord, one part I'm making out that she was under pressure for 8-9 months. It is the prosecution story, my lord. Page 24 forwarding report. Point number 2, it begins at page 24, ends at page 25. Kindly see, my lord. May I read, my lord? Lordship has found page 25, my lord, with all respect and full adherence, my lord. Of the dossiers, it comes to light that the accused persons had been undue pressurizing the victim since 8-9 months to do undue and illegitimate. How they have found that, I don't know, my lord. Have I made my position clear? This pressure was on her for 8-9 months for projection of that project, my lord. Sorry, completion of that project. Pressure is on the senior officers from the government because it is a stadium, election time or whatever be it, my lord. Project needs to be completed on time, my lord. So the pressure was on for 8-9 months. Have I made my position clear, my lord? So, my lord, with all respect, my lord, the proximity cannot be there. If the pressure, first of all, my lord, it doesn't fall within the ambit of section 45. Have I made my position clear, my lord? And one authority is specific, my lord, I'll place there. There, my lord, regarding commission of suicide, with all respect, my lord, 2 categories have been made. One, my lord, relationship, my lord, family relationship. There, my lord, husband, husband, my lord, wife or girlfriend, my lord, that is one category. And official pressure, another category, my lord, that I'll place, my lord. So this is very important, my lord. The pressure was on her for 8-9 months. Ultimately, she had to leave this world. This is very unfortunate, my lord. Here in the forwarding report, my lord, one line is there, my lord, with all respect, my lord. With all respect, my lord. 4, same page, my lord. Of course, I'm not blaming a co-accused, my lord. Whatever is there, I'm bound to read it out, my lord. Bound to read it out, and I'm reading it out, my lord. On preliminary investigation, it is found that Aminul Islam's WhatsApp chat with the deceased had mentioned about substandard materials regarding the construction work. Have I made my position clear, my lord? Not with my petitioner, my lord. Have I made my position clear, my lord? This is good, bad, ugly. And my lord, if there is corruption, assuming, my lord, assuming not admitting, my lord. Bills are, my lord, completed 66%, bills paid 40%. Rest amount, they can, my lord, with all respect, something happens, they can stop. And assuming there is corruption, my lord, if in this case they are granted bail, they will register a new case under section 7 and 13 of the PC Act, my lord. Have I made my question clear, my lord? That's a different subject matter, my lord. Because the philosophy of law is to the legislature, my lord. The legality of law for us and your lordships, my lord. Have I made my position clear? Here the entire gamut is section 45, abetment, my lord, definition of it, my lord, present BNS, my lord, BNSS, my lord, and my lord, 108 of the BNS, my lord, earlier 306 IPC, my lord. Have I made my position clear, my lord? With all respect and folded hands, my lord. And thereafter, my lord, the accused persons were sought 5 days police custody, my lord. Kindly see, my lord, why the court rejected it, my lord, because day one, suicide note was there and everything was there, my lord. It was rejected, my lord. That order I am reading out, my lord. With all respect, my lord. Page 30. The appreciation by the learned judicial magistrate when police custody was sought, he thought it unnecessary, my lord. Have I made my position clear? Page 30, paragraph 3, my lord. Lordship may have found, my lord. In the forwarding report page, the IO has mentioned the police remand for 5 days is required for further examination to unearth the facts of the case and to arrest co-accused persons involved. The case diary placed before me does not have any material to show that the accused person should be required to discover facts on their leading, etc. Have I made my position clear? So when police custody was not needed, decided by a court of law in a judicial proceeding, my lord, hereafter, my lord, 26 days in custody because of non-abatement, my lord. Thus, the ground on which police remand is sought shows that a police remand is mainly sought for further interrogation of the accused persons, which the IO can do while the accused person remain in judicial custody. Thereafter, what happens, my lord? On the slide, when the lawyers are not there, accused are in jail, because of this media pressure, my lord, these persons were taken into police custody for 3 or 4 days without they being represented by a lawyer. That's a different story. I am not on that, my lord. This order speaks that on day one, for custodial interrogation, my lord, have I made my position clear, my lord? All materials were in the hands of the investigating agency. And my lord, with all respect, my lord, Kevin. On 29th, again behind our back, my lord, they were taken to police custody for 3 days. That is good, my lord, for the sake of investigation, my lord. Now, hereafter, my lord, with all respect, my lord, why, my lord, arrest was...
Just a second.
Any query,
Police
my lord.
remand fixed 6/8/2025 for production of the accused persons from police remand. Why it is there?
My lord, when this was rejected, my lord, the family members came back home, my lord. There was no lawyer to represent them. Then from jail, possibly because of media pressure, police again sought custody, my lord. Then 3 days custody was granted on, my lord, with all respect, my lord, 29/7/25. Have I made my position clear? On 29/7, first day it was rejected, my lord. Because nowadays, BNSS, my lord, with all respect, my lord, custody can be interchanged. Not like earlier times, my lord. They again gave a prayer but there was nobody to represent the accused. Have I made my position clear, my lord?
No, where is 29/7 order you have any?
27 আছে নেকি? আছে? Huh? I'm placing the order, my lord. It is there. Luckily, my lord. Yeah. Okay. My lord, I have not read it. I have placed it before your lordships, my lord. Media. Huh? Okay. My lord, it may be pages, maybe here and there, my lord. Xerox copy of certified copy, my lord. Wait a bodlai diok, okay, kindly.
So on 29/7, the police demand was
Made, that is good, my lord. They carried out investigation. That is good for us also, my lord. That I have placed before your lordship. There the suicide note part is also. There also that suicide note part I read out, my lord. It is there blaming the architect. Sorry, my lord, the designer, my lord. Now hereafter, my lord, another place material I am placing before your lordships in the forwarding report, page 24 to also. Why I was arrested, my lord? That I am placing, my lord. Kuntu. My lord, page 25. Lordship
Yes,
has
page
25, forwarding report, my lord, of the arrested accused person. Reason of arrest. My lord, the arrest should not have been there. It is there. We are there for 26 days. Why I am stating, page 25, reason of arrest, my lord, chronologically 5. Lordship has found, my lord. I'll be very cryptic, my lord. Following the said incident, a tense situation has prevailed. And a tense situation has led to all this arrest and everything. Apparent, my lord. Tense situation prevailed in the locality, amongst the community, with every changes, possibly, my lord, this long English, every possibility of the outburst that may lead to serious law and order situation. Have I made my position clear? So it is apparent from the forwarding report why arrest was carried out, my lord. Yes, but other grounds are there, my lord, they may run away. That is next to impossible. Being government servants, my lord, retiring age, my lord. Have I made my position clear, my lord? This is one part, my lord. Thereafter, my lord, Kuntu. That proximate part, I'll come to the authorities, my lord, with all respect, my lord. This man, this gentleman executive engineer, he was transferred, my lord, from his place of posting. The date of unfortunate occurrence is 22/7, my lord. Let's lordship kindly put space on it. I'm emphasizing, my lord. 22/7/2025, my lord. 22/7, my lord. This man was transferred. Even 2 days delay, if there are ingredients are fulfilled, as regards now section 45, my lord. Earlier 107 Indian Penal Code, my lord. In that event, 2 days hiatus does not fulfill, my lord, with all respect, my lord, the completion of section 306 earlier and now 108, my lord. Have I made my position clear, my lord? If I abet, here there is no abatement, my lord. If I abet, the abatement has to be proximate. Even 2 days delay, have I made my position clear, my lord? Would not lead to abatement, my lord. Have I made my position clear? Because I was transferred, and lordship would kindly have a look, papers, my lord, official papers, my lord, page 35. I have handed over charge, my lord, in my bail application, my lord, page 35. I handed over charge on 4/7/25, my lord. এক minute, my lord. May I, my lord? Lordship has seen, my lord. Certificate of transfer, I have been transferred to Nalbari and I took over charge, page 36, exactly the next day, my lord, on 5/7/25. At Nalbari, my lord.
18 days.
There is a hiatus of 18 days, my lord. Assuming I abated earlier, have I made my position clear, my lord? There is a gap of 18 days in between, my lord. Thereafter, my lord, no connection, neither physical nor mobile. Have I made my position clear, my lord? This is the case, my lord. I'll come to the sections of law and the authorities. Prior to that, averment in my application, my lord. Because I being the executive engineer, my lord, there are several, my lord, subdivisions, my lord. The SDOs look after the work. SDOs also do not look after properly. It is entrusted to the executive, assistant engineers, my lord. Unfortunately, this lady was also, unfortunately, my lord, an assistant engineer, my lord. Can I come to the averment of my application, my lord? With all respect, my lord. I am first coming to page 7 of my application, my lord. I'm sorry, my lord. Page 6, no? Page 6, my lord. No, first, my lord, I'm sorry, my lord. Lordship, but kindly have a look at page 7, para 9, my lord. I'm beginning from the wrong end, but let me continue, my lord, because I made a note, my lord. Page 7, para 9. Lordship has found, my lord. I'm reading it out, my lord. for this petitioner, my lord, executive engineer, my lord, with all respect and folded hands, my lord, that the accused petitioner beg to state that the pursuant to an advertisement under section so and so, so and so, so and so, the work was entrusted to an contractor, my lord. He got it by bidding, my lord. Have I made my position clear? It was what so and so. Thereafter, I am leaving aside some lines, my lord. Subsequently, the contractor in question started the aforesaid construction work, and till date, he has executed physical work around 66%. It is admitted apparent in the suicide note also, my lord. Have I made my position clear? Of the cross construction, and upon submission of total bill amount of rupees 7.21 crore, an amount of rupees 496 crore have been released, meaning thereby 2.25 crore are yet to be paid. Have I made my position clear, my lord? There is no objection as such. Assuming there is some foul play, as is the media reports, my lord, then this can be held up. And secondly, my lord, if this accused is granted the privilege of bail, if there is any case of corruption there, it is not there, clarified by the government. Of course, on TV, I cannot say that, my lord. There is no illegality in the construction. Assuming there is illegality, let them register a case under section 7 and 13. Re-arrest me, my lord. How can you detain me in a case of, with all respect, that death is very unfortunate, my lord. Everybody will say, pray to God, this should not happen. But, my lord, can you link me with that for abatement? And, my lord, this amount is due. Have I made my position clear, my lord? Government has not cleared. So, money is with the government. If something wrong has been done, irregular materials, coercive measures can be taken and it can be correct. Have I made my position clear, my lord? The ball is in the court of the government, my lord. And that is not the case of the prosecution. Then there is monetary loss or that there is corruption, my lord. And assuming they find out during our investigation that there were corrupt practices, they are at liberty to register a case under section 7 and 13 of the PC Act, my lord, and do the needful accordingly. Have I made my position clear? And if they add it in this case, it will be disaster on their part, my lord, with all respect, if a separate case is not registered, because they will have to face the consequences during trial, the prosecution, my lord. Have I made my position clear, my lord? With all this is the case, my lord. Then another paragraph, my lord. Lordship, my case, my lord. Lordship, kindly have a look. Page 7, para 8, my lord. Para 8, my lord. I'm reading it out, my lord, verbatim, my lord. The accused petitioner beg to state that the assistant engineer is to look after the execution of all, this is on oath, my lord. Then this is the reality, my lord. All the work under its control and the monitoring of the work and the preparation of the bills of the work are also under the domain of the said officer. First bills are to be passed by her to go upwards, thereafter cleared, my lord. Moreover, the preparation of revised estimate, working estimate of the work, if any, keeping measurement of works in the measurement book. Measurement book is the most important thing. It is done by the assistant engineer. Lordship knows more than me. Are also within the ambit of their duties and functions and as such consider. Have I made my position clear, my lord? And my role I am coming, my lord. How can you put me behind bar for 26 days, my lord? Thereafter, my lord, with all respect, I read out page 7, para. Now, my lord, page 8, para 10. Page 8, para 10, my lord. Lordship may have found, my lord. With all respect, my lord, that the accused petitioner begs to reiterate that the supervision and monitoring of the works of the ground level are done by assistant engineer, junior engineer engaged at the site, and the preparation of the working as well as revised estimates are also done by them, and same are submitted to the divisional concern through each of the subdivision, and thereafter forwarded to higher authorities for necessary checking. And as such, have I made my position clear, my lord? Regarding payment of bills, I cannot be held responsible, my lord. Thereafter, my lord, page 8, para 10, I have read out, my lord. Thereafter, my lord, page 9, para 13, my lord. With all respect, my lord, that the accused petitioner beg to state that even on perusal of the allegations narrated in the present FIR, it is seen that the informant has alleged that her sister Aida, first informant, unfortunate deceased, had informed her that from the last few days she was facing illegal pressure and demands from her seniors, colleagues, contractors who were asking her to do some work against the work policy of the department. And it is pertinent to mention herein that the present accused petitioner has been transferred from the place of posting at Bongaigaon, that I read out, my lord, with all respect, on 5/7, and the victim of the instant case committed suicide on 22/7. There is a hiatus of 18 days of my joining at Nalbari, my lord. My lord, annexers I placed before your lordships. This is the averment I have made in the application, my lord, with all respect and full advance, my lord. Thereafter, my lord, with all respect, my lord, page 11, para 16, my lord. Page 11, this is very important, my lord. to be abetment, my lord, to fulfill the ingredients of section 45, my lord, with all respect, my lord, I have to do it either physically or by, my lord, technical devices, my lord. Have I made my position clear, my lord? I was not even in contact with her, my lord. Page 11, para 16. That the accused petitioner beg to state that the FIR there is no allegation of any mental physical cruelty proximate to the death of the deceased. Moreover, it can be seen that the deceased was not in this very unfortunate manner rational state of mind as he could not take work pressure. Furthermore, taking into account the fact that the present accused petitioner has never been in physical communication. This is very important, my lord. Let them find out if there it is with me, my lord. Communication or telephonic communication with the deceased, and to the best of his remembrance, he possibly had a telephonic conversation with the deceased, maybe in the early part of the month of May. Last communication, no physical, my lord. In the month of May, and the victim committed suicide after 2 months, subsequently so and so, my lord. So physical, my lord, committing offense, fulfilling the ingredients of section 45, thereafter falling within the ambit of present 108 is impossible. And regarding, my lord, electronic communication or telephonic communication, one phone call, the contents may be with the investigating officer, nothing to do with the work, my lord, hi, hello. That is in the month of May, my lord. Have I made my position clear, my lord? This is our case, my lord, and thereafter, my lord, with all respect, my lord, another aspect I'll be placing, my lord. This again, I'm repeating, my lord. This is a case, with all respect and tolerance, my lord, unfortunate death of a lady engineer. She should have survived, my lord, lot of the miles to go, my lord, very unfortunate. But this case falls within the ambit of, my lord, investigation is being carried out. Let it be any agency, my lord. Only, my lord, within the ambit of section 108 of the BNS, and fulfilling the ingredient, to follow in the ambit of 108, 45 ingredients are to be fulfilled. Let me just read 45. It will take a minute, my lord. Lordship would not take it otherwise, my lord. Because without 45, 108 cannot be there, my lord. And then the authorities are clear, my lord. Assuming ingredients of 45 are present, in that event, it has to be proximate. I am not there for 18 days, my lord. And my last communication, no physical, last physical or whatever be the communication was May. And May to August, my lord. May, June, July, August, 4 months. Huh? Oh, sorry, May to July, my lord. That is in July, my lord. 2 months. Now, my lord, abatement of a thing, 45. Should I, my lord? আৰু এইটো বেলেগ উলিয়াই দিবি আমি 8টা সাব ডিভিজন আছে কম্পিউটাৰ সাবডিভিজনখন লৈ লওঁ May I, my lord? With all respect and tolerance, my lord. Abatement of a thing. A person abets the doing of a thing who instigates any person to do that thing. There is no allegation against anyone that any of the arrested accused persons, inclusive of me, instigated the unfortunate lady to do that thing, meaning thereby suicide, my lord. Thereafter, the language tenor is very clear, my lord, with all respect and tolerance, my lord. Then again, small b, engages with one or more person or persons any conspiracy for the doing of that thing, absolutely missing, my lord. Prosecution cannot say yes. If an act or illegal omission takes place in pursuance of the conspiracy and in order to the doing of that thing, meaning doing of suicide, my lord. My lord, if I did not give her advice, does it fall within the ambit of 2B, small b? No. No. I'll place authorities, my lord. Thereafter, my lord, C, intentionally aids, no material, my lord, by any illegal omission, by my illegal omission, she come, no, the doing of that thing. I'll not go further, my lord. So the tenor of law is clear, crystal clear, apparent and transparent, my lord. I do not fall within the ambit of 45. When I do not fall within the ambit of 45, 26 days behind bars under 108 would be, my lord, absolute violation of 21. Because police arrested Because primarily they are honest enough, my lord, to admit in the forwarding report that non-arrest would lead to law and order situation. Law and order situation, my lord, in the Indian criminal justice delivery system, it is the duty domain of the executive, my lord. District magistrate, my lord. Have I made my position clear, my lord? Not the police and the, my lord, with all respect, my lord, I'll not go beyond it, my lord, with all respect and folded hands, my lord. And one aspect, my lord, my work profile, my lord, that, my lord, the division, I being the executive engineer, I cannot go to the nitty-gritties. And nowadays, government, my lord, every day there is construction, my lord. An entire district, how many subdivisions, my lord? 10, 12, my lord. Have I made my position clear? I do not have any physical contact, only videography. That cannot be done within the course of a day, my lord. That I have narrated. I'm just reading out for a moment, my lord. Only the cryptic lines regarding me, the executive engineer, page 6, para 7, my lord, with folded hands, my lord. Leaving aside 5 lines from the top, my lord. 1, 2, 3, 4, 5, 6, 7, 8. Page 6, para 7, lordship may. Lordship may have found, my lord. Moreover, the subdivisional officer of the respective subdivisions, my junior, my lord, there are several subdivisions under me, my lord, have the primary function to manage and execute all construction and maintenance work relating to building, road, and other infrastructure under the said subdivision, with the assistance of the assistant engineers. And it also includes the crucial role in ensuring quality and timely completion of projects, coordinating with contractors, and ensuring that all works are carried out as per prescribed standard and specifications. And as such, considering all above, have I made my position clear, my lord? And regarding these 8, 9 months of pressure, because one authority says that, my lord, I'll be reading it, my lord. If there is some illegality, there are 2 ways to the deceased lady, my lord, open to her, it was at that point of time. To complain to her superiors in writing, I think it is nowhere there, my lord. Have I made my position clear, my lord? Stays took her life, my lord. And no complaint to the police if there was some illegality. Otherwise, it's an offense, my lord. Looking at any illegalities and not informing police and higher ups, that is a criminal, my lord, misdoing, my lord. Have I made my position clear, my lord? This is the case, my lord. And thereafter, my lord, only 2 authorities, I'll be very cryptic, my lord. But already Anil Bhatta sir has read out one, my lord. That particular line I'll read out, my lord. May I, my lord, with all respect and folded hands, this is, my lord, 2024. Yeah, 2024, my lord. Nipun Aneja, my lord. Oh, my lord. I'm reading para 11. I'll be very cryptic, my lord. Only the ratio of it, my lord, not the obiter, my lord. Thus, according to the High Court rejected this application, my lord. Thereafter, it went to the Supreme Court allowed, my lord. Thus, according to the High Court, the deceased committed suicide on account of instigation in the form of harassment. Have I made my position clear, my lord? Harassment and humiliation at the end of the appellants. The question is, in what manner the appellants could be said to have instigated the disease that ultimately led to the commission to commit suicide. Para 12, prima facie, it appears there are 2 things weighed with the High Court. First, the 2 police statements of the colleagues of the deceased referred to above, and secondly, the act on the part of the appellants in handing over the letter to all statesmen. Malad, here was a meeting of salesmen after 32 years of background, 32 years of service, they were in fact orally told to voluntarily retire. One committed suicide, others did not. They were directed to take up merchandise work, meaning thereby after 32 years of putting in their service, they have to go door to door and sell products. So one, unfortunately, salesman could not bear it, my lord, stress. He committed suicide. This is the story, my lord. Now, what is the law, my lord? The legality, my lord, the ratio. My lord, I'm coming to the next page, 15, my lord. My lord, lordship may have found. Next page, 15, my lord. 1-5 quoted, my lord. There, my lord. This is a different authority, my lord. In the decision of the court in Itai Datta versus State of West Bengal, an employee of a company was transferred from one place to another. However, he failed to join. Thereafter, he sent a letter of resignation expressing his grievance. Thereafter, the said employee committed suicide. He left behind a suicide note, alleging therein that Nitai Datta and so, but the senior officials, they harassed him, my lord. Thereafter, Same, my lord. 5. There is absolutely no abetment in the alleged suicide note that a present appellant has caused any harm to him. Same is the present suicide note, my lord. 7, except the designer, my lord, or was in any way responsible for delay in paying salary. I'll not read more, my lord. Have I made my position clear? Tailor-made, my lord. It seems that the deceased was very much dissatisfied with the working condition of the workplace. Same is the case, my lord, tailor-made. Thereafter, my lord, last 5 lines, 3 I have marked, my lord. An offense under section 306, now 108, my same. Replicated, duplicated, my lord, transparent, apparently the same, my lord. IPC with the parameters of the abatement having stated. In section 107 of Penal Code 1860, section 107 says that a person abets the doing of a thing who instigates any person to do that thing or engages with one or more other person or persons in any conspiracy for the doing of that thing. If any act, illegal omission takes place in pursuance of the conspiracy, or the person should have intentionally aided any act or illegal omission, the explanation to section 107 says that any willful misrepresentation or willful concealment of a material fact which is bound to disclose may also come with ambit. This is missing here, my lord. Thereafter, the ratio 6, my lord. In the suicide note, except referring to the name of the appellant at 2 places, there is no reference to any act or incidents where the appellant herein alleged to have committed any willful act or omission or intentionally aided or instigated the deceased so and so to committing the act of suicide. Same is the case here, my lord, because the suicide note has come to the public domain, and it has come to the public domain of earlier from the order of the learned chief judicial magistrate, Bongaigaon, my lord. Absolutely tailor-made, my lord. And thereafter, my lord, with all respect, my lord, this is the author law, my lord, with all respect, my lord. As an again speak. Then I am reading para 20 on the same authority. I will be very cryptic, my lord. May I, my lord? The ingredients to constitute an offense under section 306, now 108, same tailor-made, of the IPC, abatement of suicide, would stand fulfilled if the suicide is committed by the deceased due to direct and alarming encouragement and incitement by the accused. Missing here, so far as I am concerned, leaving no option but to commit suicide. Further, as the extreme action committing suicide is also on account of great disturbance to the physical imbalance of the deceased, I'll not say that, my lord, lordship would decide. Such incitement can be divided into 2 broad categories. This is very important, my lord. 2 broad categories. Would be where the deceased is having a relation with the accused in his my lord, personal relationship, husband, wife, girlfriend, my lord, first category. Second is her official category. I'll leave the first category, my lord, but because the official category, my lord, I fall within. If I read that in totality, my lord, the official part is written here. Next page, my lord. Second line, last 2 words, my lord. In the case, lordship, in the case of secondary category, meaning thereby official relationship, my lord, where suicide takes place, the tie is on account of official relation, where the expectation should be to discharge the obligation as provided for such duty in law and to receive the considerations as provided in law. In normal circumstances, relationship by sentimental tie cannot be equated with official relationship. Definitely, my lord. The reason being different nature of conduct to maintain the relationship. The former category leaves more expectation, meaning thereby love triangle, my lord, with all respect, my lord. Whereas in the later category, official category, by and large, the expectations and obligations are prescribed by law. Have I made my position clear? Had there been ill doing, she should have been informed higher ups. She was under pressure for 8-9 months. No letter, neither to police nor to higher ups. Unfortunately, the suicide. She could not cope up. I would not say that she was mentally weak. That would be disastrous on my part. But I do not say all these things, my lord. Have I made my position clear, my lord? And thereafter, rules and policies and regulations. Absolutely tailor-made, my lord. And my lord, one part, my lordship would read out, the ratio is in 22, my lord. I'll not go into it, my lord. This is one, my lord. There is another authority, my lord. My lord, that time gap that I'm taking up. This is regarding the time gap, my lord. I'll be very cryptic, my lord. This is a latest authority, 2025, my lord. This year, my lord, R. Sasikhera versus State of Karnataka, my lord. 2025 Supreme Court, my lord. With all respect, my lord. Para 11, my lord. May I, my lord? With all respect and folded hands, my lord, from the allegations taken in the FIR at its face value, it can be seen that the case of the appellant complaining is that even much before her husband died, he used to be blackmailed by the respondent. Number 2 and 3. According to her, a day before her husband's death, her husband had been receiving continuous calls from the above persons, and whenever he received such calls, he was completely absent and had decided to commit suicide. This is the language and tenor in the facts and circumstances of that case, my lord. Thereafter, if the version of the appellant complaining is to be accepted, the question remained as to why she kept silent from 14 April 24 till 22 May 24. Have I made my position clear? Here for 8-9 months, my lord. Have I made my position clear, my lord? If there was any agony, that was not reported, my lord. As has been stated by the Supreme Court in the facts and circumstances of that case, and in this case also in the facts and circumstances, if they are taken into account, they are bound to be taken into account, my lord. The same reality will, my lord, come to surface. That is a tailor-made, my lord, with all respect. Thereafter, it goes on like this, my lord. If her husband was upset a week before his death, whenever he received calls from respondent number 2 and 3, and if was blackmailed by the said respondents, then nothing could prevent the appellant complainant from reporting this matter to police. Same is the case, 8-9 months of agony, my lord. No reporting to higher authorities, neither to police, my lord. Immediately after this, my lord, appellant from reporting the matter to police, immediately after the deceased committed suicide, that it is apparent from the material on record that all the allegations were an afterthought. Have I made my position clear, my lord? Because the affair has been lodged by the sister, hearsay, my lord, upon being told by the deceased lady. Very unfortunate, my lord. Thereafter, my lord, para 31, there, my lord, the 48 hours time frame is given, my lord. Lordship, para 13, my lord, parenthesis 31, my lord. Lordship has found, my lord, with all respect and folded hands, my lord. In the case of Sanjay Singh Sengar, this court under similar circumstances has quashed the charge sheet under section 306, now 108 BNS against the accused appellant. I'm sorry, my lord. A factor that has weighed with the court in the said case was that there was a time gap of 48 hours being the alleged instigation and the commission of suicide. 48 hours become instigation, meaning thereby fulfillment of section 45. Here, no fulfillment. Have I made my position clear, my lord? And 18 days in between hiatus, my lord. And 1st May, my last phone call. No physical relationship, more than 2 months, my lord. Suicide. This court held that the deceased was a victim of his own conduct. I should not say she was mentally weak. Here, my lord, with all respect, my lord. This court held that the deceased was a victim of his own conduct, unconnected with the quarrel that had ensued between him and the appellant 48 hours prior to the commission of his suicide. This, my lord, puts the nail in the coffin of the prosecution case, that there is no abetment, first of all. Here there was abetment. Apparent, my lord, tenor and language of the apex court, my lord. And thereafter, if there is a 48 delay, proximity is not there, the case doesn't stand, my lord. With all respect, my lord. And there, my lord, I can confirm that there are some other lines here and there, my lord. I'll not go into that. And taking cue from all this, my lord, one honorable coordinate bench of this court, my lord, here, my lord, taking into account all these authorities, my lord, one coordinate bench, my lord, there was a, my lord, with all respect, my lord, one character, my lord, RTI activist, my lord, very, my lord, infamous, my lord, Dulal Bora, my lord, he was arrested because one, my lord, some BJP party functionary died because of, my lord, incompletion of some work, my lord, with all respect, my lord. I'll be very one-liner only, my lord. Taking into account all these authorities, what the court opined and granted the privilege of bail, my lord, with all respect, my lord, in that para 36, my lord. All judgments are quoted above, my lord. I'll not go into that, my lord. Here also, my lord, this lady was a public servant, my lord. Public servant, my lord. A public servant may command appreciation from public. Can you see the line and tell us? So beautiful, my lord. But he should, here it would be C, my lord. He should also be ready to accept criticism. Have I made my position clear, my lord? If somebody accuses a public servant of committing a criminal act, it is his duty to defend it, meaning thereby he or she is to go to police or to write to higher ups. Here for 8-9 months silence, my lord, and thereafter the unfortunate suicide, and here the bail was granted, my lord. This is, my lord, whatever be the facts and circumstances, my lord. First of all, the facts and circumstances will prevail, and the law is apparent, my lord. Here instigation is missing, my lord. Ingredients of 445 are missing, my lord. Even then, had there been instigation for 18 days hiatus, prior to days, 2 months hiatus, my lord, 1st May. So far as I am concerned, my lord, had there been instigation, had there been fulfillment of section 45, even in that event, my lord, ultimately I'll never be convicted, my lord. So my detention in custody, possibly not, with all respect and full respect. My lord, another item, my lord, 29. My lord, this is pre-arrest. My lord, can it be taken a day after? We have failed to bring the file, my lord. On 29, lordship would take it up, my lord. Kindly, my lord. With consent from my move file to 9. He has agreed.
In that case, you have retained the case diary or
Same, my lord.
no, 29 you are saying?
No. Case item number 29, my lord.
No, when you are
Day
saying,
after tomorrow, my lord. Tomorrow I'll not be highly obvious. My lordship would not take it otherwise. Sir.
I have given thanks to my
No.
lord. He has argued the matter.
13.
Yes. My lord, 13 is a connected, is an FIR,
13.
same FIR.
You are on 13, no?
Yes. My lord, he is an architect.
Yes.
He's an architect, my lord. And my lord, at paste, your lordship has read the FIR, my lord.
Yes.
I don't want to repeat that FIR.
Okay.
What is the role of this architect? That's very important, my lord. Because if your lordship looks into, because I came a bit late before this court, but the suicide note, there is a suicide note which has been produced before the court, I think, my lord.
Yes.
And what it appears at page 30 in my forwarding report, kindly see the forwarding report when I was arrested on 25/7/2025, my lord. If your lordship looks at page 33, at grounds of reasons of arrest and 3, my lord. See at page 33.
33.
30.
Oh, 30.
Forwarding report.
Yes.
Forwarding which I was reason of arrest. Lordship got it? Reason and see 3. Down below 3. The suicide notes itself starts with, I am taking this step due to extreme stress from my work. I am lost and there is no one to guide me in the office. My lord, I'll just pause for a moment. We have got deepest condolence to the family, my lord, because as a lawyer, I have to fight it. As a lawyer, I have to fight, but we have deepest condolence to the family members. But all days, your lordship, no, we are always in stress. Your lordship is always stressed in writing a judgment. Doesn't mean that sometimes your lordship some extreme step. We are also in stress. In today's world, everyone is stressed, my lord. Such an extreme steps in respect of this should not have been taken with greatest respect, I am saying, my lord. Kindly see now, I was assigned to project. I was assigned the project mini stadium at Borsagaon under Boingao LLC and consultant Mrs. So-and-so, owner architect Debajit Sharma presented a hopeless estimate. Lordship has a hopeless estimate which has major discrepancy and variance. Hence, his custodial intention will reveal different aspect into the case. So, what I felt of a small 4-line suicide note, maybe a detail has been given before the court. The word has been a hopeless estimate
and which had major discrepancy and variation. Now I'll tell your lordship, this cannot be, because in this case a tender was floated separately for the architect, because there are panel architect in the department. And so far as building of the stadium is concerned, a separate tender was floated. Now, if your lordship looks into the bidding document, what I am saying, it cannot be a hopeless what they said, and there is a variation, because the victim is not to decide whether it is hopeless or there is a variation. It is a department who will decide, and a tender was floated. There is a technical bid, there is a financial bid. All this was looked into it, then my drawing was passed. So the victim cannot say that it led to suicide, because one ground is that too many of stress. Secondly, it is a hopeless drawing, there hopeless estimate, drawing and variation. Well, now I am telling your lordship, kindly look into the page 10 of the NIT. This is the bunch which you have given. At a copy here, more dear. See the NIT, my lord. This is the 19th of February 2022. What I want to show before this court, I'm troubling your lordship with this NIT, because it is a separate NIT which has been issued. My role is limited to the extent I participate, and on the basis of my participation, technical bid was there. There was an evaluation committee which is looked into it. Thereafter, financial bid was open, and I was awarded with the work. That's my role. Not beyond that. Now a contractor comes and he does the stadium on the basis of my particular drawing, which have been submitted and approved by the department. Now kindly see at page 10.
Yes.
At page 10, 19th of February 2022 was the NIT, notice inviting proposal for consultancy service. Lordship got it? Kindly see name of the work. This is the name of the work. Mini stadium. Cost is this. Total approximate 12 crores. Bid security so and so. Now my lord will kindly turn only for consultancy and architect designing. Now my lord will kindly see the at page 21. Page 21. Instruction to appellant. 2.1 is a scope for proposal. Now lordship will kindly see 2.1.1. Detailed description of objective scope of services, deliverables and other requirements relating to consultancy are specified in RFP. In case an applicant firm possesses the requisite experience capability required for undertaking the consultancy, it may participate in the selection phase individually. Sole firm in response to this invitation. Now lordship will skip this 2.14. Key personnel. The consultants team shall consider following key personnel. So what is the job responsibility? On the right hand column, your lordship will kindly see. He will lead, coordinate and supervise the multidisciplinary team. It will be his responsibility to guide the team arriving so and so. Number 2, principal architect responsible for preparation of so and so. All this goes on up to my lord mechanical engineer. Lordship got it? Now lordship will see at page 22. 2.2.2. To be eligible for evaluation of its proposal, applicant shall fulfill the following. Now, A is the technical capacity, B is the financial capacity. Now, lordship will kindly move to page 29. This is a technical proposal 2.14. What I am showing it, they can't say that it is a hopeless drawing. It is by way of a bidding process I participated, and all has been selected by the authority concerned. After my lord technical bid, I passed my technical bid. Financial bid, when we opened, it was found in my favor. An award of the contract was given. Now 2.14 at
You
page
are
20.
the architect only.
I was an architect, consultancy architect. Now 2.14 is the technical proposal, and at page 29, 2.14, the technical proposal has to be given by this consultant. Now, any of the bidder, not at that relevant time, minor selection will take place later on, but bidder has to give a technical proposal. Now, at page 30, kindly see 2.15 is the financial proposal. Lordship got it? 2.15 at page 30. Now, at page 32, page 32 is the D, evaluation process. See the evaluation process 2.21, 2.21.1, the authority chief engineer so shall open the technical proposal in presence of bidder or the representative who choose to attend a specified date, time when you has mentioned notice. In the event of specified date being declared, bid shall be opened the next working date. At the same time, venue or a technical proposal could not be opened and time due to some unavoidable reason, date and time of the opening will be notified. Now see at page 33.
Page 43.
Now see page for 35, my lord. Page 35. My lord will kindly see at page 33 for a moment. 33 for a moment, my lord. See on top, this is 2.213 at page 33A. The technical proposal is received in form specified appendix 1. D, it is accompanied by, it will be B. D, accompanied by cost of bid as specified bidding document. E, it is accompanied bid security with validity period. 2.214, authority reserve the right to reject any proposal. Lord, kindly see this way, which is non-responsive and no request for, my lord will kindly say, for alteration, modification, substitution or withdrawal shall be entertained by the authority in respect of such proposal. 2.2.15, authority shall subsequently examine and evaluate proposal in accordance with selection and criteria set in clause 3.1 of the RFP. So thereafter financial bid 2.1.6, my lord. Thereafter, your lordship will kindly see at page 35. This is the criteria for evaluation. Evaluation of technical proposal. Kindly see 3.1.3. Very important, 3.1.3. During the technical evaluation process, the applicant must make a presentation on the project. Your lordship got it? On the project, reflecting the concept of the proposed design scheme, methodology, work plan, etc. before the evaluation committee and other expert in the field as found necessary. I have been told by instruction at page 43, kindly see 43, 47, 47. Kindly see 47, my lord. Description of deliveries. See 5, my lord. On submission of detailed architectural working drawings, including floor plan, all elevation, all the crucial sections, detail of flooring, ceiling, stairs, staircase, lift, machine room, terrace, detailed interior decoration, landscaping, so and so, green building requirements, submission of three-dimensional view, model and all ancillary work along with detailed estimate, audio visual presentation, so and so. Now kindly see A, on submission approval, B, on final copy submission incorporating client's suggestion and approval. Now, 6, on submission detailed structural so and so, internal so and so, so and so.
Your drawing and estimate was
32 lakhs.
was accepted.
32,
Approved.
32, approved. This is my drawing. And suppose, my lord, there is some deviation or something, they want to increase it. It is not, I will get it, my lord. My drawing, I have made it. And there is a final call which has been taken by the department. And department awarded to this contract to me. And I have got my instruction is that 66% of the amount I have written. At page 7, kindly see, my lord, of our petition. See page 7, my lord. Para 7. Your Lordship got it? Para 7. At page 7.
Yes.
That the accused petitioner say the true facts of the case is the accused, being an MPNL architect PWD department, had participated in a bidding process for the consultant service for the work of so and so, which was floated by the Office of Chief Engineer PWD so and so, awarded the contract for consultancy for 32,60,000, and thereafter he started the consultancy work of the project. Accused petitioner further state that the accused petitioner modified foundation design of so and so after review of the site condition and soil test report with so and so. Accused petitioner submitted revised design document along with vetted drawings from so and so, which was approved. That till date, the accused petitioner received an amount of rupees so and so for the said project as consultancy fees. So 17,57,085 for the said project I received as a consultancy fees out of that 32,60,000. Already I have received my. So my respectful submission, why I read initially the suicide note, which I got, subject to your lordship has got a detailed note, and which they said in a suicide note, which I read, that it is, my lord, a hopeless estimate with major discrepancy and variation. It can't be, my biggest respect, my lord. Because there is a tender floated, I participated, is approved by the, and if it is hopeless, and so they could not have, my lord, approved this drawing, my lord. And whatever, my lord, legal point, and today I am in custody for more than 25 days. Now, there is law which has been, I don't want to repeat, I have brought this all this, the judgment of the Supreme Court. Already my learned friend, my senior friend also, Mr. Olibhotto also cited 2 judgments, and subsequently my learned friend, Mr. Mahajan also cited. And I don't want to repeat this. Only what my prayer is that today is more than 25 days. My custodial interrogation, police has sought for 2-3 days of custodial interrogation, and thereafter I was forwarded judicial custody. Now, if a trial goes on, it is only on the basis of suicide note it will go on. Now, this is what is now, with the greatest respect, what is there to keep me in the custody. This is my respectful submission. Already they have, my lord, interrogated me, and I am in judicial custody. They doesn't want it anymore for police custodial interrogation. So my humble submission before this court, my lord, more than 25 days I am in custody. So at this stage, my lord, maybe, my lord, my custodial detention is not required. And that appears, if your lordship kindly see, it is not on what I am saying at page 37. Page 37, when this matter was moved before the learned SDGM, Bongaigaon, if your lordship looks into it, peruse the case, your lordship got it. Also peruse the case record at page 37. The IO has made a prayer to remand the accused person to judicial custody. So at that relevant time, 27/7/2025, there doesn't need any my custody detention for interrogation. They have been sent to judicial custody. So my respectful submission before this honorable court that he is more than 25 days.
My laptop office which was always seized.
And all that had been seized. Laptop and everything has been seized. Computer, office material, everything has been seized. In that view of the matter, I pray before this court that after hearing my learned friend, your lordship will kindly consider my case and allow me to go on bail. And whatever stringent condition your lordship can put it, because I am MPNL, it is not this stadium I am constructed. I have made a list which I have been doing now. Kindly see.
Page 9.
This is not the first time. At page 9, kindly see. Page 9. Kindly see page 9. See the ongoing works under concept of accused petition. All these are government, my lord. There's more than more than 38 projects, my lord, government. So whatever condition your lordship put, I am ready to face it. I am deeply obliged, my lord.
Yes, my lord. This case, I have received the case diary. I have done the update for the case diary and it is available on the every case of suicide is a file. It is also a daily cost of suicide money. But here some public outrage is there because the victim is a minor, so the budding engineer minor at point of time under the circumstances, under what circumstances he has committed suicide. And my lord, thereafter, my social media also there are some reports regarding some corruption in my lord construction of that administration. So some amount of public outrage is necessary. And that's why during while my lord pointing out with the grounds of errors, my lord, that point was mentioned by the IO at the time of my lord at the time of producing the program. Now, my lord, I will just like to I will not go to the FIR of the FIR, my lord. I will point out that because suicide, the suicide note is vital in this case. My lord, not only suicide note, my lord, there are other materials in the case diary, my lord. 164 statement of the my lord witnesses, 161 statement of the witnesses. How this person, but this is not a case of my lord, not my lord. This is quite exceptional case, my lord. This is not a case, my ordinary case of my lord interpersonal dispute. Not only a case of my lord ordinary workplace case. This is something, my lord, extreme, my lord. I will point out to you later. My lord, first, regarding the suicide note, I am taking this step due to extreme stress. Well, that word was pointed out, extreme stress. But from the materials available on record, I will point out how my lord he has been suffering from continuous mental torture, coercion by the accused person, and ultimately for which my lord no option left with her, and ultimately they committed suicide. And here in this case, my lord, one accused person is my lord, one is the executive engineer, one is the my lord, assistant executive engineer, also termed as SDO, and one is architect and also consultant. He provides consultancy services. And one, my lord, already that matter has adjourned today. Rudra Pathak, he is the contractor of the entire. All these accused persons were entrusted for my lord, regarding construction of a public work. That public work is the construction of the mini stadium. The present victim, Dusita Das, my lord, she joined in the month of December 2020 in that department. At that point of time, my lord, she has no idea about the my lord construction work at that point of time. My lord, my lord experience, her experience was also not there. But at that point, she was entrusted with that work, and his authorities were the was the my lord that executive engineer and the assistant executive engineer Aminul Islam and Dinesh Sharma Mehdi. Now, my lord, he said, I am taking this step due to extreme stress from my work. I am lost, and there is no one to guide me, no one to guide me in office. I was assigned the project mini stadium at Borsongaon under Bangaigaon, and the consultant, Messrs. Aesthetic Creation, also owner, architect, Devojit Sharma, one of the equipment, presented a hopeless estimate which said major discrepancies and variations. Major discrepancies and variations. I alone had to take a leap. So, my lord, I would also like to point out, my lord, while already giving argument, there's regarding corruption, if there is any corruption link is also there, related with the commission of this suicide by the victim, my lord. And regarding, my lord, registration of separate case regarding corruption, that will come later on. But cause of corruption, corruption is one of the cause.
It seems corruption is
yes, one of the cause.
it is only the corruption. Why these
Yes,
things happen?
yes. Devajit Sharma presented a hopeless estimate which had major discrepancies and variations. I alone had to tackle it. And prior to this, I had no site experience, so no assistance from this issue either. Yet I was given this major project with no site help provided. Contractor has also not provided any site help regarding those. The contractor had no site engineer, and all the decisions had to be made by me. He had to take all this. Whether it was to guide laborer on site whatsoever, I was trying my best. Then I was expected to present a working estimate, which was very unknown to me. So she has to present a working estimate. That working estimate is totally unknown to her regarding that project. My superior, SDO Aminul Islam, and executive engineer Dinesh Sharma Medhi, two accused persons, made me continue the project on my own, despite me asking for help. So he is seeking for help, but no assistance was provided. Proper architectural drawings were not provided, and I had to prepare the working estimate based on whatever drawings given. And now I have come to a point where I am to submit the working estimate when the project is 66% completed, and I barely know the finishing items. Required. No door, window, approach, schedule, no schedule, window, door, nothing approach. No sanction provided for aluminum. I am unable to find the analysis, and I have been stretched with this estimate for 3 months approximately. No one is able to help me. So no one is providing any assistance, any help. My executive engineer and my assistant executive engineer. I am tired. I ever know where to go. My parents are worried for me, and I am unable to live with myself under this constant stress. I am having panic attacks, and I am barely functioning. I am sorry, Ma, Deta, Lisa, Aitama, Bhargav, মই ষ্টেটছ আৰু পেচেঞ্চ ৰাখিব নোৱাৰো আৰু নিজকে নিজৰ লগত মোক মাফ কৰি দিয়া মই these are not relevant মেলত মই যি পাপ কৰি ইয়াত ফচিলো সেয়া মই নাজানো মই কি কাৰণে নিজৰ সব দিন মই কলো মই কাকো ব্লেম দি থকা নাই বাট কনসালটেন্ট শুড হেভ বিন মোৰ ৰেছপন্সিবল ই এটা ভুল এষ্টিমেট দিয়া বাবদ মই আজি ইমান দিনে কষ্ট খালো চ' বিকজ অফ দি ছাবমিশ্যন অফ দি ৰং এষ্টিমেট মাৰিলো ই দিয়া এমাউণ্টটো এক্সিড হৈ যায় প্ৰজেক্ট কমপ্লিট নহয়গে মই চবৰে কথা ভাবিবলৈ লাগে সেইটো মোৰ কষ্টটো কোনেও বুজি নাভাবে মেবি মই পাছত ষ্টেপ লৈ মই মুক্তি পাম মই লগত নাপাওঁ বাট these are the my lord points so she in her statement she clearly states how my lord continuous mental stress my lord he was undergoing at that point of time and one another কিবা এটা problem this is important my lord কিবা এটা প্ৰব্লেম ছাৰহঁতৰ আগত আহিলে কৈ যে যি হ'ব একো নাই কৰি দিয়া যি হ'ব কৰি নাই একো কৰি দিয়া projector bill diatu ihotor priority. So only they are, my lord, interested in submission of the, my lord, bill of the project. Asil. Baki ji hoy hoy thak. So this is her, my lord, suicidal note. From this suicidal note, my lord, is apparent that he was totally frustrated because, my lord, working estimate was not proper working estimate submitted by the architect at that point. Suppose, yes, that is, my lord, architect is not only a architect, my lord, separate tender is there, consultancy service is there. Regarding other British persons, I will come, my lord. But, my lord, at that point of time, I will not go. At that point of time, whatever design, my lord, was provided, there is an agreement. Initially, there is an agreement with the, my lord, with the state and the contractor that this is an agreement. You will have to execute this work. You will have to construct this mini stadium. These are the specifications, my lord. These are the materials you will have to use. You cannot deviate from any specification, any design, my lord. So, my lord, in this matter, from the materials available on record, I will point out how, my lord, not only deviation of the design, how, my lord, substandard materials were used by the contractor. My lord, those, my lord, state has entrusted, my lord, upon these accused contractor to execute a particular, who are the person, my lord, on behalf of the state, this, my lord, executive engineer, assistant executive engineer, my lord, to look after the work, whether as per the agreement with the contractor, those, my lord, constructions were continuing or not, whether as per the specification contractor has used all those materials, my lord, and the architect also, my lord, that design, everything is going on smoothly in accordance with the, my lord, agreement, my lord, entered into between the state or not. But what they have done, my lord, this executive engineer, they have, my lord, totally breached, in one sense, my lord, they have totally breached the trust of the state, involving, my lord, only, my lord, they are, my lord, pressurizing this assistant engineer for submission of the working estimate at, my lord, submission of the field. Whatever materials used in the construction of the stadium, whatever may be, my lord, happen in the construction of the public works, that is not their concern. They are only concerned of getting commission from the contractor. Submit the bill, and thereafter, my lord, they will get their commission. And through which they pressurize the, my lord, victim, and ultimately, and in her statement, my lord, and the statement of the, my lord, I am not saying from, I am saying everything from the record, my lord, from the statement of the, my lord, witnesses, my lord, and from other materials. In this case, considering, my lord, public outrage, or, my lord, considering the gravity of the offense, the state has also constituted one special investigation team. Thereafter, my lord, this investigation team has, my lord, conducted, my lord, investigation in this matter. And regarding here, my lord, in this case, there are 164 statements of the, my lord, parents of the accused persons, and his, my lord, her friends, her, my lord, colleagues. 164 statement of the mother, her sister, and other two colleagues, if they are available in the case. They, my lord, specifically corroborates, not only corroborates the, my lord, contents of the, my lord, that suicide note. There are some, after a while, that my lord, construction work going on daily, there is daily conversation between the mother of the victim and her, my lord, sister. So how they can know clearly the what is going on there in the construction work site, my lord? They clearly in their state, my lord, specifically, my lord, vividly explain, and how their, my lord, daughter, my lord, her sister was, my lord, suffered, my lord, she was continuously mentally harassed, my lord, coerced by these, my lord, accused persons, my lord. So everything is, my lord, explained by the witnesses, my lord. And during investigation, my lord, and regarding the other materials of, my lord, whether the, my lord, ingredients of abetment is there or not, everything I will point out, my lord. I have also, my lord, decisions of the Supreme Court, and, my lord, already cited decisions of the Supreme Court regarding abetment, pointed out by my learned seniors, my lord, what are the ingredients in those cases. So this is not a case of interpersonal dispute. This is not a case of, my lord, normal workplace stress. It is beyond that, my lord. And under that circumstances, my lord, that ingredients of, my lord, that abetment is there or not, I will point out. I have also, my lord, some citations from the materials. And regarding, my lord, that proximity, my lord, that accused person at that point of time, that he transferred from the place of the, there are transfer order on 24/7 and 27/3. I would like to submit before you like this, because they were on the verge of transfer. That's why, my lord, they continuously pressurize the my lord, the victim that to submit the bill immediately so that they can get their commission from the contractor. And in this case, my lord, same things happens. Here, because of their pressure, my lord, running bill submitted on 27/6/25 on being certified by the accused persons and the victim also, my lord, because of their pressure, he has also signed and a running bill submitted, and that amount has already been released. And after this incident, my lord, that now the work has been stopped, my lord. And during while police investigated my lord, KIT investigated the matter, IO investigated the matter. IO has collected the my lord, seized various mobile phones of the accused person, and also visited the site my lord, where construction is going on. Whether the materials, my lord, that were used in the construction were, my lord, yes, in accordance with the contract agreement entered with the state or not. Police has also collected materials, seized, my lord, that what are the types of, my lord, materials, raw, cement, etc. used. Completely different, my lord, totally, my lord, deviated from the agreement, which is some my lord, substandard material, not in, my lord, whatever the materials, my lord, at the time of entered between the with the state, my lord, those people has to. So, my lord, while pointing out all these, my lord, discrepancies, yes, what he has very recently joined, my lord, he has pointed out all these discrepancies to these accused person seeking help. They help me because the contractor has also deviated from he also substandard material. Architect is also, my lord, architect is also pressurizing her for submission of the bill, and other accused persons also, whatever may be happen with the construction work, you only submit the estimate and bill. Because ultimately from the site, my lord, because without getting an assistance or help, the site is, my lord, looking after by the victim, my lord. Now, after submission of the bill, and what this accused person has said, he submit the bill. The Aminul Islam has said that I will again join as executive in the in that division, and I will manage everything. You only submit the bill. Regarding that also statement, that was also, my lord, during investigation, that also comes out from the evidence of the witnesses. My lord, only because, my lord, they are involved in, my lord, because of regarding corruption, my lord, why corruption comes into, because corruption is one of the cause for which, my lord, because ultimately she commits suicide, she pointing out all everything, but no one, after not getting help, not getting assistance, she commits. So that's why, my lord, corruption is centrally in this case is important. And regarding all these accused persons, in the suicide note, the victim has specifically named that these are the persons who continuously mentally harass her, harass her, and, my lord, that they are involved in creating a, my lord, hostile atmosphere, hostile, my lord, work atmosphere for the victim. My lord. Provide the entire case diary to your lordship. Your lordship may kindly go through the case diary, whether my submission the materials available on record, and whether this is an exceptional case, whether the ingredients of, my lord, abetment, my lord, has already pointed out those ingredients in those cases, there is some interpersonal issue in facts and circumstances. Otherwise, ingredients should have been, they cannot the same, but here, because of the extreme, my lord, mental torture by these accused persons, for which ultimately, my lord, it to be state, my lord, whether those ingredients, my lord, point of view, lordship. Regarding materials, regarding the case, there is waiting to your lordship. Just like point of whether in this particular case. So one. About abetment to commit defect, if press forward Chopra, versus government value. The policy has to consider the scientific materials against the accused, whether those scientific materials in fact affect the ingredients of abetment or not. At this stage, your lordship has not to evaluate in detail because investigation is still going. Paragraph 22, in the present case, I'm just pointing out only the relevant portion. In the present case, apart from the suicide note expected above, statements recorded by the police during the course of investigation tend to show that on account of business transactions with the accused, including the appellant hearing, the deceased was put under tremendous pressure to do something, my lord, which he was perhaps not willing to do. Here is the case. Prima facie, it appears that the conduct of the appellant and his accomplices was such that the deceased was left with no other option except to end his life and therefore close first plea of section 107 IPC was acted. Yes, my lord. Regarding one another citation, my lord. Versus state of Himachal Pradesh reported in 2017, 786, 780. Paragraph 42, 44, and just pointing out only one paragraph. 46. The harassment caused to her had become intolerable and unbearable. Here also, that harassment caused to the victim was intolerable and unbearable. The father had deposed that Carl had told him on number of occasions. Here, although the statement of the father, 164 statement of the father, 180 of the DNS is not there, but his 161 statement is there. Your lordship may kindly peruse 161 statement of the father. He, in fact, at that point of time, while the victim explained him about the all these mental tortures, then he, in fact, my lord, advised her daughter to leave the job, but not to go down of all these illegal cases or illegal. The harassment caused to her had become intolerable and unbearable. The father had deposed that the girl had told him on number of occasions and he had complained to the Pradhan. All these amount to an active part played by the accused. It is not a situation where a person is instituted on being asked to pay back a loan. This is it's not a situation where someone feels humiliated on a singular act. It is a different situation altogether. The young girl living in a village was pretend and is constantly. She could not bear it any longer. There is evidence that the parents belong to the village to the society. The materials on record reflect that father did not afford her treatment to the investigation. The materials brought on record that the conduct of the accused was absolutely poor. So here also the conduct of the accused and my lord regarding information unbearable total, other some paragraph is also there. But I will hand over all these questions. I will not go into all the things regarding their some of the decisions also, my lord. I would like to refer regarding granting of bail, regarding parameters, my lord. That also I will hand over to you. Submit all these so my lord, from the materials available on record and considering the my lord that investigation is at its and police has also my lord these all these my lord, and I would like to confirm one other aspect. One of the witnesses has stated, my lord, one of the witnesses, some, my lord, some voice messages was also, my lord, sent by the victim, even it message. I would not like to mention. And that voice message was also, my lord, regarding this mental torture and harassment he suffered by these accused persons. And some of the vital, my lord, WhatsApp messages, vital letters, my lord, he sent to the accused persons were already deleted by the accused person. And now those, my lord, mobile numbers were already sent to the person for retrieving all those data. And that will be, my lord, received by the police. And after arrest, now police is after arrest. If my lord, police could have arrest the contractor, then everything and the entire, my lord, the thing will come from now the contractor is something to handle the investigation. So all these 164 from this 164 statement of the witnesses, everyone stated that he was working under immense pressure from RSPO regarding preparation of bill of a project. All named all these persons. Ipsita sent me a few materials in my mobile phone where she told me that he was pressurized to prepare false bills. So my lord, some voice my lord, messages also she sent. And all these witnesses, my lord, claim these accused persons. These accused persons are who is ultimately the victim. So, they are not able to get bail. Hey, please. Well, depending on the informant. The informant also happens to be the sister of the victim. And her role in this comes in the form of first lodging the FIR, and second, being privy to the information through the communication and contact which she had with her sister before her death. Because that is very specifically alleged in the FIR. I'll not go through everything, man. I'll just give the list of it. Not that take a lot of time. In the FIR, the informant has very specifically stated that deceased prior to her death has been informing her as well as her parents. And what did she inform? She informed them about the illegal pressure and the demands that she had been facing from her seniors, colleagues, and the contractor. This is the information that was communicated to me by the deceased Joshita before her death. So I am privy to that information, and based on that information, I have lodged with the FIR. Now, one thing which is very essential here is that the victim is not on trial here, man. Now, the victim could have done a lot of things, man. That is agreed upon, my lord. But, my lord, we cannot at this stage understand the state of mind of a person, my lord, who has taken that extreme state and committed. No living person can understand that state of mind. Surely, my lord, as objectively, we can say that she should have gone to the police or she should have left the job. But that is very easy for us to say as a neutral person. But being in that position, in those circumstances, my lord, that decision is not very easy. This is a 29-year-old girl, man, for this job, a government job in PWD as an engineer, man, in 2023. After a lifetime of study, a lifetime of work, she has managed to get this job. And your lordship, when somebody is working in a subservient position or in a junior position, it is not easy to go and complain against their seniors. But we have all worked in some capacity, in some form or the other, where we had seniors above us. It is not easy to take a stand against their seniors. Likewise, my lord, it is why should have left the job? He tried to absorb the pressure, absorb the stress as much as it could be done. But eventually, my lord, she succumbed. She took this unfortunate step. Now, what are the circumstances, my lord, which prompted her to take this step? That is what your lordship will examine. Now, suicide note, my lord, the suicide note has been read. My lord, a bare reading of the suicide note, it has been projected that only shows that she was under stress, she was under pressure. But your lordship will appreciate one thing. This person was on the verge of suicide, taking her life. At that state of mind, my lord, she was not expected or she would not be in the right frame of mind to write a suicide note, contemplating that tomorrow this suicide note will be used for the purpose of prosecution. So that point will never be there, my lord. That lady, my lord, who has died, is not a legal expert, my lord. She is not conversant with the legal terminology which is required to be put in a suicide note so that a person can be prosecuted or implicated in the case. Whatever she was facing, my lord, she stated there. Now, my learned friend, my the public prosecutor, has also read out from some of the materials from the case diary. My humble request is that your lordship will kindly consider the case diary to see whether the suicide note is the sole material on the basis of which the accused persons are being prosecuted, or there are other materials, ma'am. If it is the suicide note alone, then also your lordship will examine whether proximity of cause or the ingredients of, my lord, abetment of suicide are there or not. But my lord, my humble submission is that because we know, being told by the deceased before her death what all she was facing, the kind of pressure which was piled upon her to prepare, my lord, and pass inflated and, my lord, wrong bills, my lord. So that pressure was upon her. If there are materials in the case diary support this allegation, my lord, then it cannot be said that this is a case where only because of pressure or stress exerted upon the victim she took this step. So what is the case, my lord, eventually about? Case is about, my lord, preparation of inflated and fraudulent bills regarding that mini stadium. Now, one thing which has been argued, and my learned senior colleagues, as far as the law is concerned, are correct, man. That is the correct proposition of law. That proximity has to be there. Today, somebody is doing something illegal. At some future point of time, if person commits suicide, that will not cover. But your lordship can be see. But the forwarding report very categorically says that the accused persons had been pressurizing her for 8-9 months. It is not a question of pressurizing her 8-9 months ago. It is a question of a systemic pressure going on for 8-9 months. In fact, the tense which has been used had been pressurizing her since. That means it suggests, my lord, a continuous pressure which was piled upon her. Because the project was not yet complete, my lord. As per the material which have been read out, the project was only 66% complete. The project was not complete. Bills were not yet, all bills were not cleared. She was put under pressure to prepare inflated bills, my lord. So this pressure was there. And in fact, even after their transfer, my lord, even after their transfer from that particular place of posting, even thereafter, my lord, there were regular calls, regular messages, and again, my lord, will examine the case diary whether the police has been able, because we know, because that is what Toshita had told us, that they had been regularly calling her. In fact, they had, even when she comes to Guwahati, my lord, she was asked to come and meet them, because even after their transfer. So it is not that after transfer, they have lost all interest in the project. Even after transfer, they were piling pressure upon her to come meet them here and ensure that these bills and all these reports, which allegedly are fraudulent, my lord, those are prepared. So this is a continuous pressure. So proximity, when your lordship will examine proximity, proximity is not from 8-9 months ago. Proximity is because up to the day of her death, this pressure was there. That is what she also writes, that she is unable to bear the pressure. That's a continuous pressure from 8-9 months ago, systemic pressure which goes on. And one more thing, my lord, with all due respect to what my learned senior colleagues have pointed out, the law on abetment, it does not come only from direct acts, because the lordship knows this very well, my lord, that while deciding the question of abetment, it always depends upon the facts and circumstances of each case. So in certain cases, my lord, there will be direct acts. In certain cases, my lord, there can be abetment by way of words, by way of insinuation, by way of, my lord, indirect acts, my lord. So it can also be through words, it can be through actions, it can be through conduct. So depending on each case, my lord, then my lord, the question of as to whether this is a case of abetment of suicide or this is a case of a very hypersensitive person who has committed. This is not a case, my lord. The lordship will examine the case there. Whether there is anything to show that this girl was hypersensitive and that is why this girl could manage to study, get good marks, get into engineering, clear engineering, and land a government job, my lord. So she has been able to withstand stress, which many of us perhaps could not, my lord, during our academic year. So she has been able to withstand stress. This is not a case of a hypersensitive person taking her life. This is a case of a person, my lord, not a case of any 29-year-old girl committing suicide. This is a case of a public servant, my lord, who has committed suicide. So there are two aspects. A young 29-year-old girl being put in a situation where she is unable to resist this act. Plus, my lord, this is also a case where the seriousness comes in, my lord. A public servant has committed suicide. The public servant. So, my lord, in these kind of cases, my lord, if a very lenient view is taken, my lord, this will also act as a fetter for other persons, my lord. Because corruption is something, my lord, which is endemic to the country, my lord. Everywhere there is corruption, my lord. Everybody knows that, my lord. Tomorrow, any other person faces corruption, my lord. If the lenient approach is taken, my lord, that person will also feel very apprehensive of coming forward, my lord. This will also debar whistleblowers from coming up, my lord. So, my lord, in this case, my lord, I am humbly submitting that this is a case where no leniency should be shown, at least at this stage, my lord. These persons were in the department, even after transfer, they were able to exert pressure. Even if they are released from jail, my lord, the possibility of hampering and tempering cannot be ruled out, because whether there was corruption or not, whether these bills were inflated, and all of these are, my lord, based on, my lord, materials which are there in the department office, my lord. These persons who are around 57, 58 years old, my lord, they have access to those things, my lord. And plus, they also have other people working there, my lord. So the possibility of hampering and tempering at this stage cannot be ruled out. Let the, my lord, investigation progress significantly, and then, of course, my lord, one day or the other, they will get clear. At this stage, this is not the stage, my lord, in my respect. And, my lord, because whatever the allegations which I have leveled in the FIR, my lord, based on what was communicated to me, my lord, this chain of possession is clearly established. Cause of her death, the circumstances leading to her death, my lord, the chain of possession is clearly established. And at this stage, my lord, any release of the accused persons on bail, my lord, will create definite pattern on the way the investigation progresses, my lord. And, my lord, most, my lord, custodial interrogation or custodial detention is not the only parameter for deciding whether a person should be kept in jail or not. Gravity of the offense, my lord, remains a most relevant factor. So just because they have not been interrogated at this stage or their police interrogation has not been sought at this stage does not necessarily mean that they should be released on bail. So, my lord, that will not take much time, my lord. Much has been said from both sides, my lord. So I'll keep my submissions confined to these facts, my lord. I'll humbly request that HCPS should not be done. And just one judgment, my lord, I will realize, just because to counter whatever has been said. At the end of the day, it all boils down to the fact, man. Some cases it may not be a factual case. Because, once we were in training, my lord, we were given this example. I still remember this example. My lord, a teacher, if a teacher takes a strong action against a student, beats up a student, though it is not permissible, or expels him from school for doing something illegal, tomorrow the student commits suicide, my lord, the teacher will not be liable. But, my lord, if a teacher is part of a conspiracy to ensure leakage of a question paper, and one of the students is also being pressurized that you also be a part of it, through you, let the papers be circulated among your fellow students. Now that student is in a dilemma. He is not in a position to resist or to complain against the teacher. At the same time, his conscience also does not allow him to be a part of that paper leakage or cheating. So now, if that student commits suicide, my lord, in that case, my lord, because this is not a legitimate act on the part of the teacher, so in that case, my lord, the teacher will be prosecuted, not in the first case. Here also, the allegations are not regarding legitimate acts, my lord, not acts done in good faith. The allegations are specific malafide and malice. So, I will kindly come to page 317, internal, my
Para?
on page 317, my lord, internal page. Para 14.2, page 317, my lord, will kindly come as sub para 34. Lordship has it?
Yes.
The word abetment has not been explained in section 306 IPC. In this context, the definition of abetment as provided under section 107 IPC is particular. Section 306 IPC seeks to punish those who abet the commission of suicide of others. Whether the person has abetted the commission of suicide of another or not is to be gathered from facts and circumstances of each case and to be found out by continuous conduct of the accused involving his mental illness. The word instigate literally means to vote, urge, forward, provoke, incite, or encourage to an act. A person is said to instigate another person when he actively suggests or stimulates him to an act by any means or language, direct or indirect. So it does not have to be direct action. Whether it takes the form of express solicitation or of hints, insinuation or encouraging. Instigation may be in express words or maybe by implied conduct. The word urge forward means to advise or try hard to persuade somebody to do something, to make a person to move more quickly in a particular direction, especially by pushing or forcing that person. Therefore, a person instigating another has to vote or urge forward the latter with the intention to provoke, incite, or encourage the doing of an act by the latter. In order to prove abetment, it must be shown that the accused kept or urging or annoying the deceased by words, taunts until the deceased reacted. A casual remark or something said in routine or usual conversation should not be construed or misunderstood as abetment. So regular in acts and in regular course of duty may not those who have never amounted to abetment. Keeping in view the aforesaid legal position, we are required to address whether there has been abetment in committing suicide. Be it clearly stated that mere allegation of harassment without any positive action in proximity to the time of occurrence on the part of the accused that led a person to commit suicide, a conviction in terms of section 306 IPC is not sustainable. That is what my learned senior colleague had also read. A casual remark that is likely to cause harassment in ordinary course of events will not come within the purview of justice. A mere reprimand or a word in a fit of anger will not earn the status of abetment. There has to be positive action that creates a situation for the victim to put an end to life. In the instant case, the accused had by his act and by his continuous course of conduct created such a situation as a consequence of which the deceased was left with no other option except to commit suicide. The active acts of the accused that led the deceased to put an end to her life. That apart, we do not find any material on record which compels the court to conclude that the victim committing suicide was hypersensitive to ordinary petulance, discord, or difference in domestic life, quite common to the society which they belong. On the other hand, the accused has played an active role in tarnishing the self-esteem and self-respect of the victim, which drove the victim girl to commit suicide. The cruelty meted out to her has in fact induced her to extinguish her life spark. Well, this is also a case where because of the systemic harassment, systemic pressure put on by the accused person upon the victim to do illegal action. That is the whole crux of the case, man, to do illegal act. Now, if there is nothing in the case that to show that they have compelled or forced or put pressure upon the victim to do an illegal act, then there is obviously no case of abetment. But if there are materials to that effect, apart from the suicide note also, man, in that case, man, this still is covered by abetment. So that is my respect for submission. So this is a case covered by section 108 of the PNS. So in such case, and considering the fact that the public servant had committed suicide, but her entire life was ahead of her. The parents had only two daughters. One is living in Bangalore, she was living here. She had just got the job. She had an entire bright future ahead of her. And at this stage, my lord, just at the inception of her career, she has completed. So that has to be looked in as an aggravated. That is my response.
May I just say two lines?
Sorry, I have heard you at length.
Maladhi, what they have said, only one line, my lord. If Malad Krishna has said, my lord, public podium speaking is different. Because police complaint, I have not created. That is his understanding of law. Supreme Court has three decisions, my lord, that I have already placed, my lord. That police complaints are the 2 months of harassment. Have I made my question clear, my lord? Arnab Goswami is, my lord, I have not cited. If Arnab Goswami is read, there, whatever they have said, all are negated, my lord. Philosophy of law is to be left to the legislature, my lord. Sentimentality and everything, my lord.
Sentiment is otherwise.
And if there is corruption, my lord, they are to attribute corruption, my lord. There has to be a section of law prescribed, my lord. And in the suicide note, there is no allegation of corruption, my lord. The inflated bills, this word has come up. And regarding the executive engineer, my lord, he never talked to the lady, my lord, never ever, by asking her to pay bills, my lord. That may be looked into, my lord. Regarding executive engineer, my lord. And after retirement, my lord, he pressurizing, that is redundant even prior to when he was holding office, he never sought inflated bills is their creation, my lord. It is neither in the suicide note and nor, my lord, I have done it ever in my life.
By passing those inflated bills, how will be benefited, that we'll have to see.
Exactly.
How you will be benefited.
And my lord, then
Because
my,
you are there.
yes, Lordship is very correct.
Before the
Lordship, I
transfer,
agree,
you
my
are
lord.
there. So even after the transfer, you are putting.
Yes,
such
whether I
content
have
on
done
her.
that, my lord.
That means by
No,
passing
my lord. That is his
inflated
saying.
bills,
Lordship,
you will
kindly
just
see
get
whether
some
I really,
benefits.
whether I
That's why
really
those
pressurize
bills are
that.
there.
Whether I talk to her regarding
No,
inflated
that's
bills.
what I'm saying. Even after your transfer, you are have a talk with her. Even after your transfer, that means what? Definitely, you will get some benefit through
Exactly.
passing those
My lord,
inflated
Lordship,
bills.
kindly hear me.
That is the
No, exactly, my lord. Whether I have talked to her after retirement, that may be looked into. That is not regarding me. Regarding the other person involved, possibly, my lord. I have never done that because it is in the forwarding report itself, my lord.
We have this one. This what? No. EB. Question is that you are going to retain the case diary. It will be. I'll look into it. The case diary. But the other one, the
29th, my lord.
AB is on. We may fix it on day after tomorrow. Then order will be only one day, I think. Day after
Exactly.
tomorrow, every order should be there.
My lord,
I'll
my
prepare the order and then will be passed only on the day
My
after
lord, my
tomorrow,
lord, my
after
lord.
hearing you.
My lord, that day we can do it. My lord, here Lordship may kindly have a look at, my lord, that Arnab Goswami one, my lord. All these points, podium speaking, my lord. It is there, my lord.
Give the para, specific para.
My lord, Lordship, that day I'll place it, my lord. When I go for the pre-arrest bail, my lord, that will be better.
Place it because
Oh, my
that
lord.
day it may not be possible to prepare all the four orders. So
My
we
lord,
pass the half done and 29
Then my
again
lord,
will pass. You just give the paras.
Suicide notice said, I have not blamed anyone. That is in my lord Arnab Goswami. I'll place it and place it before your lordship. And after post-retirement, I have never talked to her. Prior to retirement also, my lord, kindly find out any telephonic CDR that I pressurize for bills, not to take about inflated bills, my lord. My role is not there, my lord.
I have already
CD
pointed
two
out
bracket.
the-
It would it wrap.
আজিকালি চেম্বাৰত যায় ভইচ নিটো লিখি দিব লাগিব
The malicious use of their position for committing illegal crime.
whether kindly ask him, my lord, whether I talk to her post-retirement or pre-retirement, my lord.
Transfer.
After transfer and even not even prior to transfer also. I never talked to her regarding bills, my lord.
Now you got retired.
No. I will posted at a different place, Nalbari, my lord.
Oh, yes.
That proximity, my lord.
You're not a retired person.
No, not a retired. Transfer, on transfer, my lord.
18 days.
18 days, not a retired, my lord. There were wrong submission. Highly ordered.
Really not question.
23. Maybe on Friday,
No.
from Uday.
Uday, madam.
Next Monday.
Friday we can't because there are some matters.
Mine.
Friday it's not possible.
Possible Monday.
No.
Oh,
Second man. Second.
Are you on interim day?
No.
no.
2-9.
CD not specific. We try to get it by today.
Public.
Item number 30, that's the last item. The matter could have been actually almost disposed, but the other side has filed an I. They've taken the signature from this. And if it doesn't reach, their shield. If it doesn't reach, we just want to fix perhaps 29th of this month. Lordship. Right?
You have filed an I.
Yes, Lordship. Then we'll file objection immediately. Then 29th, it may be.
In IA, you have received the copy of the I.
Copy today and they have filed it today.
So we'll file objection as well and
No,
hope to
one
get
I is here, I criminal,
our,
which,
yes, our I in the, that
your I criminal is 834.
834, we have got
Okay.
relief in it. Actually, the matter could have been disposed.
Oh.
The matter could have been disposed of. All we need is running water, electricity in the bathroom. There are CCTV cameras in objectionable places, and the son is being mentally harassed a lot. These are the 4-5 objections we have. But we are trying to sort that out with the protection officer as well, protection officer. So this matter could have been disposed because this entire DV matter is a summary procedure, and it is going on in the trial court. Could have been finished, and the cross examination of the aggrieved is also done. So it's in the last stage. It is in the last stage of being completion. So there is absolutely no way reason for the matter to go on. However, because they have filed an I was hoping that there is a date, because if there is a leftover, we will not get it. That is why I've mentioned that if we get a date, we'll file objection, and the same day the court meets on 20.
You file one I.
I file one of it.
Otherwise, you are the respond number 2.
Put a respondent. And if any earlier date also is given, as your lordship's convenience, we are ready to bring the objection and the matter may be disposed of.
And the I criminal 834 was filed by you.
We have, and we have got relief in it. We are in the house now, but we have only this small few issues.
As you said, the council appearing on behalf of the respond number 2, and also heard you are
P. Chakraborty.
P. Chakraborty. P. Chakraborty, the Learned Council appearing for the petition. It is submitted by MS Secretary that the petitioner has already filed one I, and which the copy they have received today, but needs some time to file their objection. She further submitted that the matter could have been disposed of today, but as they have filed an I, they wants to submit an objection against said I. It is not received by us, na, till now.
No, no. No, no.
You have already filed today.
Today only, Your Lordship. After
But
we
I've
received
seen
your
that
file.
the said I is not tagged with the case record. Accordingly, the registry is hereby asked to tag the said I filed by the petitioner side on or before the next date of listing. List accordingly want to list it on 29.
Or any earlier date,
Earlier,
your lordship.
Earlier date, so most probably it will be difficult. Maybe on 29.
29 August.
29. List the petitioner, the respondent side is at liberty to file written objection, if any, on or before the next.
Very pleasure, Lordship. Lordship, I beg to mention, Lordship, item number 19, Lordship. CD was called for, CD was not received, Lordship. Here is tacit submitted, ma'am.
Yes, CS number?
Yes, number 41 of 2020.
41 of 25.
20.
Dated?
They have not mentioned it, ma'am.
Then to we cannot say.
Ma'am. We have received the tacit submitted.
Take the proper instruction date without date.
Then we will have
Yeah.
to verify.
On item number 19, na?
19.
In that case, are you on interim date?
No, Lordship. No.
Leave a card, Mr. K. Thakur, Learned Council for the petition.
Lordship, I'll appear before the concerned court as and when I receive the summons, Lordship, if charge is submitted.
Do you want that any further instruction is to be taken by the, the state petitioner respondent? Or this
If that-
41 is there. but
Session
date
number is
not.
there, Lordship, it's okay.
Okay then. You have charge number to date. It's liberty to approach the learned trial court below with an appropriate application for bail, which may. Okay.
That may be part of the part of it. Lordship, my prayer is that I'll appear before the trial court when as and when I receive the summons, Lordship, otherwise.
20 as and when means if charge is there, then you will receive.
Yes,
So
sir.
you are at liberty to approach.
Please.
Deeply obliged, ma'am.
Right, please, your lordship. My lord, here in this case, petitioner is behind the bar for last 26 days, my lord.
You're also charge sheet submitting.
Okay, what is CS number?
My charge sheet number 154 of 25,
154/25,
dated 28/7.
2008.
28.
Oh, sorry, 2807.
07. 154.
Okay, then Mr. Manaf, you
20.
appeared before this trial court below.
My lord,
Then-
I left personally.
Okay. So we are going to dispose of the
My lord.
matter.
Obliged.
May I please, Your Honor?
What is the position of 11?
Yeah, so justice has been.
CD is it?
Charge sheet submitted, my lord.
Here also justice submitted. Yes, what is the CS number?
Fine. Charge sheet number 268 of 25,
Yes,
dated 17/8. 2019.
recently.
The 248.
Okay, Mr. Bora, appear before the learned trial.
Ma'am, will appear before the trial court, ma'am. Obliged, ma'am. My lord, I stand corrected. Actually, the period of custody should be 60 days, not 90 days, ma'am. And today is 66 days, my lord. Because all the offenses are below 7 years, my lord.
Yes. You are today on 66 days.
Fine. 65 days.
60, today is 66, 65, 66. I was
Whatever,
arrested on
beyond
40.
the statutory. Now, what is the position?
My lord, we have received a case diary only on 14th for my lord. 14/8.
You received on 14.
Fine.
There
Before
is,
rejection.
is there no,
Fine.
the charge sheet is not yet filed. I think. So otherwise, as Mr. Das is submitted, it is only 60 days of 61 to 3184, then 3162, 3363,
2 years, 340, 7 years.
all are up to 7 years.
My lord, if I, your lordship permit, 61 is 6 months,
61 is 6 months, then
318.4 is 7 years.
Hmm.
316.2 is 5 years. 336.3 is 2 years.
No, my lord, 3162. That is 5 years, my lord.
Oh, 5 years.
3184. That is 7 years.
3184, 7 years. That is
7
what I
years.
said.
336 of subsection 3. That is 7 years.
336, 2 years. 2 years.
3363.
7 years, below 10 years
3402, man.
is 7 years.
up to 7 years. Otherwise, what about your materials?
Well, it was earlier rejected, madam, after going to the case, madam. What
Oh,
happened?
what
You
is
guys secretary
conducted,
tells
conducted.
the final.
Okay. Materials are there.
Materials.
Heard Mr. H. Das, still on it counsel for the petition. Heard Mr. B. Sharma, the learned edition PP, appearing. This is an application of Swenson in connection with Swenson CD receipt. It is submitted by Mr. Das that the present accused petitioner is in custody since last 16, and wherein the statutory period is of 60 days, and thus, but till date, the IO could not furnish the case and search, and hence the petitioner is entered of Mr. Sharma, the learned edition PP submitted in this that there are sufficient intimating materials against the present petition, and his petition was also earlier rejected in terms of the case diary. However, it is a fact that till date, the IO could not find the judge. In view of which, without going into the detail of the merit of the case, only considering the length of detention already undergone by the petitioner. To whose satisfaction? This
CGM Kamrup Metro.
CGM Kamrup. Okay, we are done. Yes.
May please, Your Lordship.
14, what is the position?
Madam, here charge sheet submitted, man.
Yes, submitted. Are you on interim there?
Yes, Lord.
Okay.
How many petitioners were there?
One petitioner.
One.
Only
Or
one.
it- madam.
My lord, can we extend it 30 days to
But
8
sorry, at best we can extend it 20 days, not more
Fine.
than that.
14
So you want 20 days?
Madam.
Oh.
One charge sheet number
Yes.
47 of 2020.
47, 25,
And that is 28 to
2802, 2020.
Fine.
So we are extending your interim till 20 days.
My lord.
Appear with.
Master please.
Oh.
16.
May I appeal, Your Lordship?
Yes, what is the
Madam,
position?
CD not
of the-
received.
Not received.
CD not received.
Last,
Are you on interim? No.
no,
No, madam.
Lordship, interim protection may be given, Lordship. Here the allegation is that, Lordship, the petitioner has made some statement against India during the India-Pakistan war, Lordship. But the IO is not submitting his CD or report, anything is not submitting petitioner. The IO is not also provide the case number also, Lordship. His
To you?
petition- Yes, Lordship, petitioner, Lordship.
But you have filed a case.
I filed the case, Lordship. I am harassing, Lordship. The IO is coming again and again in my home and searching me, Lordship.
But
And-
case number is not there.
City Hall, yes.
The
I
last-
see
Last
case number is
three
not there.
times, last 4 times, 19/6/2025, this novel court called the city lordship or record lordship. But
Huh?
still now,
Is it? When called?
I'm for the petitioner lordship.
No, since when you are.
From Borgola police station lordship, till Kata district.
No, say 1906 is the first date I think.
First date.
That was called for fixing 1777.
77, there are
17/7, the case was not put up, I think.
yes, lordship, argumentable lordship. There are 28/7 lordship. Therefore, again, today is 18/8 lordship.
No, you're saying that you're not supplied with the case number, that's what I'm asking.
Yes, lordship, they have not provided me case number, not any charge, they have not issued any notice, lordship. That I have
Case
given.
number he is not having any case number.
Minor.
So I'm not following you.
Minor. I will have to take it that. Yes.
Last
Madam, I think the 17/7 class there is a left one.
left.
That I don't know. No, here is
That's
no.
why-
Oh, yes, maybe.
Minor. That's why we are confusing minor.
Acha.
Petitioner is just a driver lordship, and he has.
So you are in the apprehension that you may be arrested.
Yes, and they are coming again and again in my house, but saying that
Not the
Cases, you are not in a position to say whether case is registered or not.
or not. Yes, lordship.
Acha.
Whether any.
But you know that you post some
minor.
anti-Indian posts.
I have not submitted any post in the Facebook regarding against Indian lordship.
Then why you are apprehending?
That is the fact, lordship. They are again coming again and again in my house and searching me, lordship. And that
On what allegation they have searched?
allegation is that
That you have posted.
No, lordship. I have not posted it. If I am posted, then why they are not submitting the CD or charge sheet,
No.
anything, lordship? Why they are not submitting, lordship? If I post
That
it,
means you
if I
want-
have
you
done
have
any
to
crime, lordship, then
corporate
just.
report otherwise.
Minor.
Yes.
Oh, acha, that is one confusion I think.
Minor.
Because I don't know, on the last occasion, there was a, by
nine-
coordinate bench, it was passed, order was passed, then only case jury was called for. That makes us confusion. in fact. Otherwise, we could have called for a report.
Report may be
But on
called
the
for.
very first day, 1906, only CD was called for by the coordinate bench.
Yes.
But that is the confusion. Anyway, we're calling for the report.
Yes, short date may be given, lordship.
We'll try.
Short date may be given.
You are Mr.
NH lordship.
Are Mr. NS and H. Luster, the learned concept petition. Mr. B. Sharma. It is submitted to Mr. Sharma that he did not receive, but on basis of the record, seen that the, that the present application has been filed only with the apprehension of arrest by which police station you are harassing?
Borkola police station,
Under which district?
Kacha district, Lordship.
Acha. Borkola police station of Kacha district. Uh, district. So they have not provided with any case number or a copy of FIR, etc. In advantage, the CD was called for. So the report is to be called for from the concerned police station as to whether any case has been registered against the present petitioner in the said police station. The learned additional people will take necessary steps in obtaining the report from the concerned police station. Districts according when it can be?
My lord, that may be 26 or 27.
26.
27 maybe, Lordship. 27.
27.
27.
27. We are fixing.
Yeah.
Sorry.
I am obliged.
My lord, here CD not received. My lord, they are in interim.
You are not
Yes,
Okay, then we are extending interim your interim. So it will be called for issue remand. It's not says only. CDB remand. When can be called?
My lord,
8th of September.
my lord. Second one.
Second, there are many. I think. Let it be on 8th of September.
My 8th, my 8th.
Your interim, you are extending your interim.
My lord, in this matter, my lord, FSL was called for. The issue is that, my lord,
You
the
have
wife,
received the CD here. I think.
My lord, we have received the case there, my lord, without EM and FSL report, my lord.
so, my lord,
Here, my lord, it was sent for as per, my lord, on the the CD itself, my lord. It was not certain, my lord. After it was sent for FSL, my lord. It was sent for FSL, my lord. That report is not received here, my lord. Along with the EM report also, they have not applied. Along with the case.
Your report is not available. But on the last occasion, one order was there.
My lord.
Call for the relevant FSL report along with the updated case there.
My lord.
So you returned it. The
We
case
have
diary was
received the
returned.
case date on 14/8, my lord. 14/8.
No, you returned or received?
No, it was taken, my lord, because we have received on
Received on 14. That means
14.
it was returned.
My lord. Okay. Then here it is stated, my lord, FSL report pertaining to above mentioned case has not yet been received from the forensic laboratory. That's why
But PM report is not
not yet,
available.
not.
so, my lord, my prayer is that, my lord, there is a totally false allegation. The deceased was admitted in the hospital, my lord. His wife, my lord. And twice he has taken her to the hospital, given the treatment, and out of a serious disease, she unfortunately ultimately expired, my lord. So, my lord, I pray that, my lord, my interim protection may be given, my lord. Police harasses me like anything, my lord. So,
Oh yes, okay. You may be true. Your
I'll
suspicion may be
cooperate,
correct,
my lord.
but I don't know. I mean, the case is registered under 103. So
Right.
minimum period of the case diary is required. Because
There is-
allegation is not that. Allegation is that you have killed.
My lord.
That is the allegation.
That is, the allegation, your lordship may go through the FIR. What is the allegation? They have admitted that I have a very good relation, and twice, and admitted that she was suffering for a long period of various disease, stomach pain and anything, and so many diseases, my lord. But in the FIR it is mentioned. And only that, my lord, thereafter they afterthought they suspected that, my lord, after consuming the medicine prescribed by the doctor, she felt uneasy. And again, I admitted her to the name care hospital at Guwahati, name care nursing home, my lord. So if I have the bad intention, I should admit him to the civil hospital, government hospital. So what is, I only, my lord, afterthought, they have only just to harass me, they have just her sister has lodged the FIR, my lord. Implicating that I have some intentional, given some poisonous things mixed with the medicine, my lord. This is not, my lord, it is a frivolous allegation, my lord. So considering this, your lordship may provide interim protection.
My lord, here if we go for the merit of the case, my lord, here implication against the then matter. The FIR itself said that, my lord, আগত মোৰ ফলিকুলো পয়জন খুৱাই মৰিম বুলি ভাবুকি দিছিল my lord. Thereafter, when he consumed the medicine, my lord, then he suffered some. My lord. Here, mentioned by the some of the cases, my lord. After consuming it, she felt burning sensation internally. Witness, my lord, the witness said that after the consuming it, she felt the burning sensation.
Mr. Sharma, that is there, but the question is that it may be some medicinal effect, I don't know, or maybe poison. That also, doctor, that's why this report is
My
required.
lord, no,
Otherwise,
I'll talk to.
so you're going to retain the case diary,
My lord, my lord.
or it can be.
My lord, retain the CD, and in the meantime, I'll talk to my lord Kochi consult regarding the PM report and everything.
So my lord, a short date will be given. Last more than 1 month, my lord. That.
Not in behind the bar, my lord. It's the entity.
But police is again and again harassing my lord.
Administrator has not still on petition. Part Mr. Bishop. It is submitted by Mr. Sharma that though CD receipt, the CD is not accompanied with the FSL report and the PM. Considering the nature of the I find it necessary to call for the FSL report and along with the PM report. CD be retained with nature of this. The meantime, the action prepare will probably necessary steps to procure the FSL report and the PM report from the IO first. When it can be listed? 4th of September?
September. August. September, it will be very late, my lord. More than 1 month.
We don't
No,
have
today is
dates.
18.
18.
4th of September?
4th of September. Plus.
But Sharma, can you retain the case there till 4th of September? It may not be possible.
You know, we can
Return the case. Return the case up to date. Along with sweat. That will be, I think, better option. Because 4th of September will be fine. Yes, what is the 20 position? You have received the case there?
I not here not received case there.
Case number not received?
Yeah,
Are you on interim, Mr. Ullah?
Interim, my lord.
Okay, then we are extending your interim.
Yes.
CD not received, issue reminder. Interim be extended till next date of listing. Where from it has to come? You have your need.
Borrowing money.
4th of September can be given?
8th, my lord.
8th of September. We are extending your interim. Two you are appearing, Hussein.
I'm too low.
Mahmood is appearing on 21.
Yes, I am 21.
Yes, 2. What is your submission? 2.
Right, please, Your Lordship. My lord, 49 days I am in custody as on today, Lordship. 49 days. And there are allegation under section 319, 340 and 362. 36. In my humble submission, Lordship, 336 and 340 does not attract, Lordship.
Against you.
Do not
Against you.
No, Lordship.
No, it doesn't attack against you.
Yes, Lordship. If offense is admitted, it comes under 319 and it is bailable section, Lordship. Allegation is that I was found as a fake candidate in an examination hall, Lordship.
That means at best against you for 319
For
will come.
319, Lordship, 319 and it is bailable, Lordship. Because in examination hall, there is nothing to be forged, Lordship. 319 is personation, cheating by personation. That may 319 to cheating by personation. That may at best come lordship if offense is admitted. So it is bailable session. And lordship 49 days as on today, I'm in custody whether on the day of alleged offense he was taken into custody. And after forwarding, he was not taken into police remand because no further investigation was required. Therefore, lordship, whether further custody is required for the purpose of investigation, lordship. Length of detention may kindly be considered, lordship. This is my humble submission.
Yes, Mr.
My lord, so far item 21 is concerned, here are few sections, 415 of BNSS, BNS,
1-5?
415 BNS, that is IPC 319.
No, yeah. IPC 415.
Yes. IPC is cheating, definition of cheating. Yes.
319, yes. Now
So,
319.
so my lord, my submission is this, I am not there.
You are not the,
I am not in the examination center.
you are not in the examination.
Yes.
On behalf of being
I am submitting. My learned friend would definitely submit. My lord, my submission is this, I am not in the examination center.
Hmm.
Now, how I have cheated someone or manufactured the document, forged the document, because person is not here. Kindly consider this aspect. Forgery of document, that means I have to do something which is forged one, fake one, but I am not there. And the documents which have been seized by the examiner is not written by me.
Well, answer scripts are not written by you.
Yes, not written by me. Secondly, my lord, 336 forgery. How it can be forgery? Because man is not there. Neither he can commit any forgery, nor he may make any fraudulent document, nor he can appear for examination for others, that is cheating by personation. Now, it is said that the person who has been arrested, who is my learned friend, is now submitting before your lordship, he has implicated me. Lordship is our duty implication of one accused by another. That is very weak ground. So, my lord, we will face trial, and everything is based on document, my lord. Documents are in their custody, not in my custody. So I have no chance to hamper, temper, or any influence over any person. I do not know who are the witnesses also. Definitely it will be the center in charge or superintendent of the school concerned. So for a man like me, it is not possible to influence them. So my submission is they will face trial, kindly grant us bail.
I from the statement of the co-equipment. It is both of them has that is or Sohidul Rahman, although he was not present in the examination hall, he was the person, his name was there for examination. But on behalf of Sohidul Rahman, that name, Asker Ali, he appeared. When the examination hall in the signature investigator and dear minor, he asked to signature, but Asker Ali confused to put his signature, whether he put his signature or Sohidul signature. Then it was come to the light. Then it come to the light that investigator also think that he is not the person. And when seen it as the statement in the examination hall, Akhtar Ali putting his cap in his head but in the admit card it was not there and there is some was informed to the principal then principal verified come to like that photo in on behalf of Tahirul. And statement of the Asker Ali, it was revealed that both of them since the admit photo in the admit card. Both of them. And regarding the AD it is not a case to granting as on his behalf, my lord. He gave the admit card to the my lord, Asker Ali. And thereafter, both of them sent the photograph and appeared before in the examination.
A simple answer, madam. My learned friend has said that there are photos of this accused person, that is, my lord, Shahidur Islam. I am not there. Who put the photos of mine in the answer script? How can I know?
But you have given the admit card to the
My learned friend,
appear
please,
before.
it is a criminal case. Proof beyond reasonable doubt is necessary. Now, my lord, I am Shahidur Rahman. Whether this photo was pasted there by me or someone else, I have no idea because I am not there.
Why don't you appear in the examination?
No, I have not appeared in the examination.
Why? Why?
My lord,
After receiving the admit card and all, you have not appeared. Why you have not appeared in the examination?
that
You are
explanation, my
repeatedly
lord,
saying that you
I
were
am
in the examination hall, outside examination hall. That means you have not appeared in the examination.
outside
Why?
the examination hall.
What one kind of examination this one is?
My lord, it is SOS, my lord.
SOS.
Some,
As I am instructed, Lordship, SOS is state open and school.
Open.
Examination
HS
for
exam.
some left out students, Lords.
For HSLC.
My lord,
Like
HSLC.
HSLC level examination
Achha.
for some left out students.
SOS.
Ah, yes.
Yes.
my lord, why I will, if I remain outside, then what will be my benefit? If I do not sit in the examination, what is my risk? So far, my learned friend has said that my photo was pasted. How can I may be connected with that photo? Because I am not there. Nor police arrested me and compared the photos of both the persons. Now, if your lordship kindly grants me bail, I will appear definitely. I will cooperate with the investigation. At that time, police
No, but
will,
my question is that it is the one opportunity given to you.
my lord.
Because among the, as Mr. Hussain is submitted, there's some left out students, that is the opportunity given by the government. SOS examination was there.
Yes, I
Some left out students so that can appear and can avail the examination.
yes, police
Can.
may
But why
compare.
you are outside? Why you have not appeared? That is my question. You should appear.
No, my lord. I will appear because at present I
Why,
have apprehension.
why did you appear? Because that
I
was the
have,
opportunity given to you only.
my lord, rightly or wrongly, when police is behind a person, he runs. Because police.
No. I'm not on there. You have not appeared in the examination. You were saying that you were outside.
Yes, I am.
Admit card was issued in your name, but you have not appeared in the examination.
No,
Why?
in my net, I did not appear, so I did not think at all. Because my lord, some persons may send for examination, may fill up their forms, but due to difference, he may not appear. But does it mean that I am the criminal?
And okay.
Should
So-
consider my length of the. I
So,
will
my
testify,
lord,
Lord.
I will appear before the IO.
Maybe you have submitted whether in BA anything you submit.
My lord, regarding the
BA, he is only
Yeah, my
submitted
lord.
the 49 days in.
49 days, my lord, he has appeared on behalf of the Shahidul Islam. my lord.
No, that
He
is
was
there.
caught red-handed in the
Yes,
my
red-handed,
lord,
yes.
examination.
So further custodial.
My lord, not even consider the length details only on the, but regarding 80 my lord, and the
But matter is same case. Case is same, and my photo has to be compared. If I cannot go to police station, then how the police will get the chance to come?
Already done something. I
Right.
think that part is already there. Anyway.
Normally, my lord, detention is the not the motto. Detention is not the motto. Motto is to cooperate with the investigation. That I am ready. 49 days or no, AB, that is immaterial. Material is this, whether I am cooperating or not. If your lordship kindly grants me some time, I will cooperate under any condition. If I do not cooperate, my bail may be cancelled.
Number 2. Had Mr. M.I. Hussain, they done a considerable petition. Also heard Mr. P. Sharma, learned PP, appearing in the state. It's an application. CD received by Mr. Smith. It is submitted by Mr. Hussain that the council for petition that the present petition. He has not committed any such. That he is his case also does not affect the other section except the section at best it may affect section 319 subsection 2 which is available. The further submitted that accused is in custody since last 49 days and hence considering his length of detention also he may be released on bail. On the day of arrest, since the day of arrest, he was in judicial custody and no police remand was sought for.
Your Lordship, kind permission, one submission.
Yes.
First thing is this, my lord, the other sections, those are not applicable in my case because I have not written anything. That is very important because when someone will prepare a fake document and will say it is genuine, I have not prepared the document, nor I have placed before anyone, so that does not count. No, it is a law. Kindly see the.
It's okay.
Yes. So if I prepare a false document and I produce it before some authority to get some benefit, then only this 468 or 471 will come. Here, at best, if the other party has said that he has appeared on my behalf, that is sitting my persuasion. That is valuable.
So
My lord, my junior would be here, my lord. I have.
So submit. Considering the length of detention for last time. Police remand. Next step, Mr. Sharma, the learned petition PP submitted in this regard that there are sufficient incriminating materials against the present accused petition. And when he appeared on behalf of the co-accused in the examination hall, there was he had some confusion while he was asked to put his signature in the answer scripts and on the photographs also had some suspicion on the invigilators, and accordingly this matter has come into the light that he is appearing in examination in the name of co-accused by forging even by changing the photographs and thus forging the admit card. Accordingly, he submitted that the bail petition may not be considered at this stage. Next, hearing this submission made by learning have also perused the case record diary, and it is seen that there are sufficient incriminating materials against it in the case record, and the investigation is still under process, and co-accused is yet to be named in connection with this case. In view of this, I do not find it the case to extend the privilege of bail to the present petition stage, only considering the length. In view of this, the present petition is dismissed and some is rejected. Your petition is rejected. Coming to the next 21. Hard Mr. M. Mahmood, so. It is submitted by Mr. Mahmood that the present accused petition is no way connected in the alleged offense, and he was never inside the examination hall, wherein his co-accused is alleged to have been arrested with the allegation that he appeared examination on his behalf. Thus, he submitted that the case is not effective against him, neither under section 319 subsection 2, nor under section 340 subsection 2, or 336 subsection 3, BNS as alleged. However, he is ready and willing to extend his cooperation in the investigation of this case if he is granted with some interim protection. Next paragraph, Mr. Sharma, the learned petitioner PP submitted his statement that he is the main culprit of the entire case, and he is the person who, and the co-accused only appeared in the examination hall on his behalf by action by changing the photographs and forging the admit card. The person is still absconding, and there is and his custodial detention is required to know the actual fact of the case. Accordingly, Mr. Sharma raised objection and submitted that this is not at all a fit case to extend the privilege of pre-arrest bail to the present petition. Next paragraph, hearing this submission made by learned counsel for both sides, I have also perused the case diary, and considering the materials available in the case diary and the nature of offense, wherein the one of the co-accused appeared examination on his behalf, even by forging oblique exchanging the photographs in the admit card, and thus considering the gravity of the offense, I find that custodial interrogation may be required for the interest of the investigation in view of this present petition stand dismissed. 21 is also dismissed. Rejected.
Oh, like.
22.
May I please, my lord? My lord, 482 application, my lord, FIR is
CD you have received here.
Did you receive my note? Earlier also, no, earlier even some of the matters listed people were working on 30, 15, or 38 matter.
38, co-accused man.
Regarding my lord, theft of one dumper, they have started to keep Margarita PST.
Oh, you were on interim, I think, na?
Yes.
Yes, my lord, the petitioner is not named in the FIR, my lord.
You are the scrap shop owner.
Yes, my lord, I am one of the scripts
One of the prospective passenger, but he has not purchased.
My lord, what? My lord, one of the mediators has approached this petitioner to purchase that script, but since after verifying the documents and everything, since nothing was there, so therefore this petitioner has refused to purchase the vehicle, my lord. And my lord, he has already appeared before the IO, his statement already recorded, my lord. So as such, my lord, he is not involved, my lord. He being a script dealer, my lord. Somebody has approached, he went there, but after verifying documents, he find nothing is in order, so he refused. That is his role. He is not named, he is no way involved, my lord.
Earlier BA number 235525. Suicide witness on the ground of length of detention.
Lordship has guaranteed, my lord.
54 days, you will have to granted bail.
These are BAs.
Oh, it could not be heard on that day.
Yes, I do not know that, my lord. The other matters were listed on that day. Actually, I have missed.
Your matter was also listed?
On the, yes, my lord, it was in the bottom part, my lord, and the due to
Oh,
paucity of time it could not be taken up, my lord. And I do not know that these BAs are also listed.
So he appeared before here.
This time he has not purchased.
This is very unfortunate because there are many scrap dealers or scrap shop owners.
Yes.
But these things that stolen goods have in
Here, my lord, big
Yeah.
size dumper cut into pieces. Parts, my lord, somebody has purchased cabin, somebody has the doors of the dumper, and thereafter, my lord, while woman came
But
to
these
know-
were subsequently it will be sold on this weight basis or what? After cutting this
after
parts.
cutting, they sold it, my lord, but they're
No, no, on I mean this kg or kilo, I mean weight basis only.
Yeah.
Apart from that, the whole car will be
some high value
high value.
because part of the cabin, engine, everything is.
Engine is also there.
Yeah.
That is item number 20. Sure. Mr. A.K. Gupta, the Learned Counsel for the petition, and also Mr. D. Bottom, the Learned Petition people. It's an application under section so and so in connection with so and so, CD receipt. It is submitted by Mr. Gupta that the present petitioner is innocent. And after obtaining the order of interim pre-arrest bail, he appeared before the ICE, cooperated in investigation, and his statement is also recorded under section 181, that is ABNS. He further submitted that on the day of incident also he was supposed to purchase the parts of the vehicle, but when he came to know that there is no document of said vehicle or other things, he did not purchase the purchase in for his at shop, and does not talking of it. However, he is still ready and willing to extend his cooperation for the investigation. Next one, Mr. Bottom, done submitted in this for obtaining the order of clearance bail. He appeared before the IU, and his statement is also recorded. He is extending his cooperation in the investigation of this case. Investigation of this case. However, he submitted that none of this investigation. In view of this, and considering the conduct of the investigation and other aspects of the mandated witness to extend the privilege of clearance bail and the relation, and accordingly, the order of interim pre-arrest bail dated
25/7/2020.
25/07/2025 is hereby made absolute with same terms and conditions.
Obliged.
Yes. What about 24?
24 and 25, my lord, same matter, my lord.
Same.
Both two FIRs.
24, 25, my lord. Although it was case number is different, my lord, it is among these.
My lord,
As per IOM.
And two FIRs were there.
two FIRs.
Typically, it was
Same subject matter, my lord. It was returned among them.
My lord, may I request your lordship
so
to kindly,
not of same FIR, but it is among
Among.
because the
Subject
case is
matter is
subject matter.
may I request your lordship to kindly take up item number 25 first, because it is on the first FIR. My lord, the first FIR was,
Mr. Burba. Item number 25. Wait. Yes, what is it? 25, no?
25. Now, the FIR comes from page number 10, my lord. No, it was lodged by Saiful Islam. My lord, he was the owner of the vehicle bearing number NL01N9529, the offending vehicle. It is written that I am the owner of 14-wheeler goods carrier bearing vehicle number so and so. Rabiul Islam, the accused, son of Shahjamal Ahmed so and so, and Hasibul Sheikh, he was the handyman therein. Both has been employed as driver and handyman of the vehicle since long. On 29/10/2024, Milo, at Durgapur, West Bengal, the vehicle was loaded with 30-ton so-and-so road
And while proceeding towards Tinsukia on 2/11/2024, at around 5 p.m., the GPS connection and contact with the driver was lost. While the GPS connection of the vehicle was lost from the jurisdiction of Bogribari PS station, the driver took the vehicle near a tea stall at Blasipara, Maspara, and dropped the handyman and another person, Kalam Sheikh. And after that, the driver flew away with the vehicle, and it is suspected he might have sold the rods, keeping 1.5 tons. Now, basic allegation is that I have loaded the vehicle from Durgapur, West Bengal, and on 2/11/2024, I have dropped this Hasibul Islam, the handyman, and one person, namely Kalam Sheikh, at Maspara, Bilashipara, and I have flew away with the loaded vehicle, my lord. This is the first FIR. Now, the second FIR, my lord, is a little bit contradictory to the first FIR, because the second FIR, my lord, lordship will find it at page number, the translated portion. Page number
So you are
18, my lord.
in 25.
Yes, my lord.
You are Robial. Oh,
I'm
both
Robiul Islam, I'm the driver. Both are Robiul. The
So
two
you
FIRs.
you are the driver?
I was the driver of the vehicle, my lord. Now, in this second FIR, my lord,
This FIR is lost by the owner of the vehicle or
the first FIR, my lord,
owner of the
yes,
vehicle.
yes. The first FIR, my lord, it was filed by the owner of the vehicle. Now, the second FIR, my lord, although the second FIR says, second FIR says, my lord, lordship will find in it page number 18, my lord.
In second case, 24.
Item number 25, my lord. We have annexed both the
both the FIRs.
Both the FIRs we have annexed.
Where it is?
Page number 18, my lord. I will read the vernacular section, my lord, page number 24, my lord. May kindly come to page number 24. Now, the FIR, my lord, has been lodged by Ratan Datta. This Ratan Datta, my lord, he was the owner of the consignment at Durgapur, West Bengal. He was the owner of the consignment. Now, he stated that Honman Purbak Binito Nibedon Eije, Zua Ingraji, my lord, have found. Zua Ingraji 30/10/24 তারিখে রবিন দাস পিতা সোয়েনসো বিলাসীপাড়া ওয়ার্ড নম্বর সোয়েনসো ৰঞ্জিত নগৰৰ সোয়েনসো নম্বৰৰ ট্ৰাক গাড়ীখন 30 টন সোয়েনসো TMT ৰোড ভৰ্তি কৰি পশ্চিমবংগৰ দুৰ্গাপুৰৰ পৰা দুলিয়াজানলৈ বুলি নিশ্চয় কৰিলে আৰু দুলিয়াজানলৈ ল'বলৈ নিয়াৰ কাৰণে কথা বতৰা হয় আৰু তেওঁক 3 কিস্তি কৰি মুঠ সোয়েনসো টকা আদায় দিয়া হয়. So here in this FIR, Ratan Datta, the informant has stated that Robin Das was the owner of the vehicle, so and so. He has stated Robin Das so and so, Gari so and so. But Robin Das is actually not the owner of the vehicle. This Saiful Islam, the owner, the informant of the first FIR, he is the owner. Robin Das happens to be the business partner of that. Saiful Das, he used to procure the consignments. He used like a business deal, my lord. He is the owner. He used to rent the vehicle and a kind of business partner. He was not the owner. And my lord, I have also stated I was not employed by Saiful Islam. I was given the task to load the vehicle in the Durgapur by Robin Das. I was not employed by Saiful Islam. I was employed by Robin Das. Now, the second, my lord, continuing, my lord, Pasot 2/11/2024, it is same 2/11/24 ইংৰাজী তাৰিখে গাড়ীৰ চালকৰ লগত ফোন যোগে কথা বতৰা হয় যদিও তাৰ পিছত কোনো ধৰণৰ যোগাযোগ পোৱা নাযায়। ফলত গাড়ীৰ মালিক ৰবিন দাস, here is also mentioned Robin Das is the owner but he is not, ৰবিন দাসক যোগাযোগ কৰাত তেওঁ কোনো চিন্তা কৰাৰ কাৰণ নাই বুলি আমাক জনায় যদিও আমি গাড়ীখন বৰপেটাৰ হাউলি থানাত ৰখাই থোৱা বুলি জানিব পাই মই যোৱা 5/11/24 ইংৰাজী তাৰিখে তাত যাওঁ আৰু থানাত খবৰ লওঁতে এই গাড়ীখন বালাজী কাঠাত আছে বুলি কয় আৰু মই প্ৰথম চালকক যোগাযোগ কৰিব নোৱাৰাত গাড়ীৰ হেণ্ডিমেনক ফোন কৰাত তেওঁ মেলড মে কাইণ্ডলি হেভ এ নোটিছ অফ দিছ যোগাযোগ কৰি নোপোৱাত গাড়ীৰ হেণ্ডিমেনক ফোন কৰাত তেওঁ ভিডিঅ' কলৰ যোগেদি গাড়ীত থকা মালখিনি ৰড দেখুৱাই দিয়াত আমি গাড়ীখন মুঠ 1.5 ton, half ton, 1.5 ton manhe road tate dekha pao. So, my lord, the first FIR, the owner says that I have dropped the handyman Hasibul and one person in the Maspara and I flew away with the vehicle. The first FIR, although, my lord, the first FIR, actually it was lodged before, with the Bogribari PS station much before this FIR. on 6/11/2024, my lord. Now that due to jurisdictional errors, that case was been transferred to Blasibara police station on dated 1/2/2025. But that was the first FIR. Now on 6/11/2024, my lord, the owner, the actual owner, my lord, he says that the driver, I mean, I have dropped the Hasibul Islam, the handyman, as well as one person at Bilasipara Maspa, and I flew away with the loaded vehicle. Subsequently, on 18/11/2024, the actual owner of the consignment, my lord, he says that at first he contacted me. Now, while I was not in the contact, he contacted Robin Das, who he has said that he was the owner. He contacted him. Robin Das, my lord. Robin Das, amak kuno চিন্তা কৰাৰ কাৰণ নাই বুলি কয়. He assured them there is nothing to worry about. And secondly, the handyman Hasibul Islam, my lord, he has shown the vehicle in a video conferencing. So I am not there. My lord, I was only given a task to load the vehicle at Durgapur and drop it to the Masfara, Bilasipara Masfara. I have done that. My task was only that, because I am not a permanent employee of that vehicle, my lord. I have to go to some other states also. So on that day, my lord, I loaded. Yes, of course, I have loaded the vehicle.
You are a driver.
I was the driver, my lord. Now on second
You are
11.
not the driver of the vehicle.
Huh?
You are not the permanent driver of the
I'm
vehicle.
not the permanent driver of the
Who
vehicle.
engaged you?
Huh?
Who engaged
This Robin Das, my lord. Robin Das, the business partner, not the actual owner. Robin Das employed me as a driver of that vehicle to carry the loaded vehicles from Durgapur to Bilasipara Maspara. My task was completed therein. Now I handed over the vehicle to a handyman as well as Robin Das, my lord. Now the second FIR, my lord. I mean, yes, the second FIR being lodged by the consignment owner. He has clearly stated, my lord, that he called Robin Das because Robin Das dealt with the business. He thought he's the owner. He called Robin Das. He said, "Kuno cinta korar karone." And second thing, who has shown the vehicle in a video conference, my lord? So my case is that, my lord, I was only given a task to drop that vehicle there, and I've handed over all those documents. I've handed over everything to Hasibul Islam handyman as well as Robin Das. And thereafter, I went to some other states for which I could not be contacted, my lord, because I have to go in some other vehicles also. And till date, my lord, I think recovery has not been made.
What happened to this? I don't know. What happened to I don't know.
I am not. I don't know about that, my lord, because I was only employed temporarily to load the vehicle at Durgapur and I dropped it to Maspara. That was it.
But in both the FIR,
Yes, my lord.
one this particular aspect is said that in the first FIR also it is seen that 1.5 tons only left in the truck.
Yes, yes.
And in the subsequent FIR is also seen that the rest it was particularly loaded actually 180 kgs of rock.
30 to 180.
30 tons, sorry, but
280 kg.
afterward 1.5 tons only
0.5
remained.
ton was remaining.
That is the similarity in both the FIR.
Yes, yes. Some similarities are there, but main aspect is who was at the last end. You know, after on 2/11/2024, the vehicle was parked there in Bilasipara. Now after that, the first FIR was done in 6/11/2024. Later on 18/11/2024, and the video call was done on 5/11/2024. All this
booked to Durgapur or what?
actually in the no, actually in first FIR it is mentioned Durgapur to Tinisukia, and second FIR it has been mentioned in to Duliajan. So there is also contradiction between the
West Bengal.
Yes, from Durgapur, West Bengal. I have been named in both.
Proceeded towards Tinsukia. Loaded in Durgapur.
Loaded in Durgapur.
Connection was lost on Bogribari.
Bogribari at on 2/11/2024. So my case is, my lord, I am nowhere engaged with this offense. I was given a task to park in there, hand over the documents, hand over the keys, hand over the entire vehicle to Robin Das as well as the handyman of the driver. And thereafter, I went back to some other vehicles, my lord. That is basically my case.
My lord, here I have received a case there, my lord. Although there are two FIR, my lord, after investigation, police found that there are similarities in the subject matter, my lord, and both of them amalgamated. My lord, here, Rubiel is a person, my lord. He is the main culprit, my lord. He is the driver of the police, my lord, who have stolen all the, my lord, notice, my lord, 30 tons, 30.4 kg of, my lord, iron rod, my lord. and he is missing from the meat melon, from the road melon. And not even the destination, if the destination melon, so meet the melon. Here melon, sufficient letter there against green melon is not a case melon to given the interim protection or field melon. Here, regarding seizure melon only Madam, 39 bundles of TMT rods, approximately 1800 kg square. It was recovered, madam, and it was given to the original owner, madam, of the mother. But others is yet to be recovered, madam. And from the mother, there is given that he is the custodian of the, as he is the driver of the vehicle, madam. He is the custodian, madam. He is a duty to madam and to get the destination, madam. But he, the although my driver, he said that my another handyman and other person were taken down from the vehicle. It is clear from the handyman, statement of the handyman matter. They are taken down from the vehicle matter and they are left up. And here is a matter objection as some of the materials that yet to be recovered and he is getting there. His custodial interrogation is very much necessary to recover to see the other material which are yet to be recovered.
So handyman was, where was he? Handyman?
My handyman his statement here, madam. মই দিন হাজিৰা গাড়ী চলাওঁ যোৱা কেইদিনমান আগতে ড্ৰাইভাৰ ৰবিউল ইছলামে গাড়ীত যাবলৈ কোৱাত মই প্ৰথমবাৰ তেওঁৰ গাড়ীত হেণ্ডিমেন হিচাপে তেওঁৰ লগত গাড়ী লৈ গুৱাহাটীৰ পৰা মাল লৈ কলকাতালৈ গৈ দুৰ্গাপুৰৰ পৰা ৰড বজাই কৰি লৈ আহি থাকোঁতে মোক ইংৰাজী ২/১১ তাৰিখত সন্ধিয়া ৫:৩০ মান বজাত গাড়ী লৈ আহি মাছপাৰা তেল ডিপুৰ ওচৰত এখন চাহৰ দোকানৰ সন্মুখত গাড়ীখন ৰখাই মোক আৰু ড্ৰাইভাৰৰ ভতিজা কালামক গাড়ীৰ পৰা নমাই দিয়ে আৰু আমাক ঘৰলৈ পঠাই দিয়ে পিছদিনা শুনা পাওঁ যে গাড়ীখন তাত নাই পিছত বিচাৰি গাড়ীখনৰ হাউলিত পাইছে বুলি শুনিছোঁ গাড়ীত থকা ৰড ও চালক ৰবিয়াল ইছলামক পোৱা নাই ড্ৰাইভাৰ ভতিজা কালামে কলকাতাত ফুৰিব যাব বুলি যোৱাৰ সময়ত ট্ৰাকখনক উঠাই লৈ গৈছিল
So only that is the question. Only 1.5 ton were remain.
My lord.
And which was through videograph also. I mean,
My lord,
video recording also.
shown that, my lord.
It was shown that 1.5 ton were left.
My lord. And from the Robindas, my lord, this statement is also here, my lord. He is the owner of the vehicle, but he said that মোৰ গাড়ীখনৰ পইচা দিব লগা থকাৰ কাৰণে গাড়ীখনৰ নাম ট্ৰেন্সফাৰ হোৱা নাই গাড়ীখন কিনাৰ পিছত মই হাপি তোলাৰ সি কিনা নামৰ পৰা ব্যক্তিজনক ভাগ চলাবলৈ আৰু গাড়ীখনত চালক হিচাপে পদকীয়া ৰবিউল ইছলামক নিয়োগ কৰে This is the main culprit, my lord.
24 and 25 second. You are Mr.
S.S. Ahmed, my lord.
Yes. Part Mr. S.S. Repetition. Part Bishop. This is an application. Connection, 24 connection. Okay. That's it for PS 25. I would take the connection. In connection with so and so. আপনি দুইটা লক কৰিব because it is an emergency. So it is subject to Ahmed with an auto petition. That petition is it. He is no way connected in the act. The fact that he was engaged as a driver by one Rovindas to on the particular day for to transport some iron 30 tons of iron rod from Durgapur, West Bengal towards Tinsukia. And after bringing it to the destination, he handed over the key, the vehicle, and other documents to said Rovindas, and he left to the other state and for other state. As he was engaged temporarily on the day of incident, temporarily, he was engaged as a driver on temporary basis by said Rovindas. He left the place to the other states, and for that reason only he could not, the informant could not make any contact with the British. However, coming to know about the lodging of the FIR, he had filed the present anticipatory bail applications so that he can appear and can cooperate in the investigation. He further submitted that there are contradictions in two FIRs filed by, basically filed by one Saiful Islam, who stated to be the owner of the vehicle, and the another FIR lodged by one Ratan Datta, who claimed the owner of the consignment. He submitted that in the first FIR lodged by Saiful Islam, it is seen that as per allegation, he dropped both the handyman and one kalam in Bilasipada, and left with the vehicle and fled with the vehicle. But in the subsequent FIR, it reveals that the informant had a video call with the handyman, who showed the vehicle with 1.5 tons of the iron rod. Thus, two contradictory statements has been made in the two evidence. However, he is ready and willing to extend his cooperation in the further investigation. Next part. The Sharma Delane Television PT submitted in this week that two FIRs has been launched in the police station, in Bogrebari police station, but subsequently, as it was found that the subject matter and the cause of action of both the FIRs are same, the IO had amalgamated both the FIRs and started the investigation. Submitted by Mr. Sharma that the present accused petitioner is the main culprit, the entire allegation, and he is the person who fled with the 30 tons of iron rod, and suspected to, and it is suspected that he sold out the mm, so how many tons were, as per the, how many tons were there in the vehicle?
30 ton 280 kilo. 30 tons
1.5.
280 kilo. Oh, leftover. Left at 1.5 ton in the vehicle.
Approximately sold out the and leaving only 1.5 tons in the vehicle. He suspected he sold out the rest of the portion of the iron ore, which was loaded in the sea. Further, he submitted that sufficient incriminating evidence so far collected against the present petition, showing his direct involvement in the alleged offense, and accordingly, he submitted that it is not at all a big case to extend the privilege of pre-arrest bail to the present petition. Next, hearing the submission made by the his diary which reveals that the IO has collected sufficient materials against the present petition. The statement made by two informants, that is Saiful Islam and Ratandas, it reveals that he fled away with the truck, leaving the truck near the station, and thereafter the truck was recovered from Borpeta Road.
The statement of handyman.
Of handyman is also, and the statement of the handyman. It provides that informant and statement of the handyman. And the truck was subsequently recovered from Borpeta Road with only 1.5 tons of the uh, which was loaded in the same truck. So considering the entire circumstance of the case and the nature of it, I find that custody interrogation may be required for the interest of the institution. In view of this, I do not find it effective to extend the privilege of pre-arrest bail to the present petitioner, and accordingly, vote the petition statute. Your petition statute. What is the position of 26? No one is appeared. None appears on petition. Are you going to return, or it can be returned? All for the case diary along with medical report. Where the medical report also received? Can it be written till 27, 28, or I don't know, there are 4 cases. At one more chance, maybe. But it's a holiday. 1st of September. 1st of September is a working day. It's a Monday, okay. 1st of September, where none appears on call. CD received along with the medical report, written the case diary till next listing, list accordingly on 1.
May I please, your lordship? This is for 82 bail application in charge.
Here also you have CP case diary.
Elsewhere was received, lordship.
Of scan copy.
Scan copy.
I have not gone through my first.
It is just, lordship, my humble prayer before your lordship. The petitioner is interested to participate in trial, lordship, and also is the consequences of trial, lordship. Kindly some protection will be given to the petitioners. Petitioner will appear before the court below. Next date is fixed, lordship, 10th
10th of
September, lordship. My humble prayer
So
before.
what is the position? You are against you, the NBW is issued?
No.
Not
Not
yet.
interview issue. A summons, lordship.
Only summons.
Yes, lordship. My limited prayer before, lord, because
Earlier
already
it's
too
not-
late.
the
shortly.
copy was not legible.
My lord.
Incident was occurred in the year of 2007, lordship, and also charge sheet was filed, lordship, 2023, lordship, after the 15 years almost, lordship.
But you have not appeared.
Yes, but my humble prayer,
For last 2 years.
some
My lord, here the go through is 370 D.
Pardon?
376 D also edited.
yes,
376D.
D man.
at the time of file the charge sheet, lordship. But lordship, in this charge sheet, lordship,
We can do
all
at least one thing, 10th of September, the next date is fixed.
Before that.
He can appear.
yes, lordship, any
Only someone is issued.
yes,
now.
lordship,
Have you annexed the order sheet here?
yes, lordship.
You are not extending.
Someone is lordship, page number 50, and lordship, page number 47. 47, lordship. Any condition, imposed any condition, lordship.
Any condition?
No, we cannot extend any anticipatory to you.
Fine.
Only that
Yes, lordship.
no corrosive action may not be
Yes,
taken.
yes,
against
lordship,
you
yes,
till
yes.
Only for 10 days or 15 days.
And till
for
next
15
day.
days, because 10 September is too far.
Yes, lordship. Yes, lordship.
15 days, 10, 15 days. We can.
And the court will consider as per law.
Oh, obviously, obviously.
Yes,
Then 376.
Date of the API. But if something proceed, fixing the matter on 10, no, 15 days, and in between that period, the API, and as it's already given 15 days time,
So on that day, he's on Indian. So,
No, but the question is that he may be on some, suppose not on, we are not extending any previous bail. But if suppose he is asked to appear within 10 or 15 days, that's it. In between, because that's why I'm asking is whether it is summons case.
Yes, Lord.
He may appear, but the court may not consider also because it is 376D. And if it is considered after hearing him, then it's okay. Maybe a case for consideration, may not be a case also. Now, what you want to submit, I just could not follow you. You want to submit that?
For APN. And he before prior to that 15 days. May only proceed that.
Or till his appearance.
Which way?
But in that case, if he appears on, say, 30
Before,
days later,
if 15 days is given, he appears before 10 days. Then he is remain for interim for only 5-6 days. That is also good.
Look,
If he appears prior to day 10, so Lordship, and then the court below will decide as per law. Because Lordship, until till the day of his appearance, that interim protection, that no perceived
Because-
will be there.
Lordship, petitioners are interested to participate at time. That's why Lordship.
10 or 15, then after till 10, that protection will be there. If he do not appear on he appears on 12, Lordship, then there will no.
automatically.
Yes.
Till that.
But you are Mr.
A. Alim Sheikh Lordship.
A.
Alim Sheikh. S.
Full number, I think. A. Alim.
Oh, last week was the Monday.
Is submitted to Mr. Sheikh? No. Scan copy of the ECR have already been received. It is submitted by Mr. Sheikh that the present he was not involved in the LS. Further, he submitted that during the investigation, police came for search for him, and for which he was not aware about the pendency of this case. The case was, the FIR was lodged in 2007, and the charge sheet was filed only in the year 2023, and hence he was not aware about the case.
Two petitioner.
How a two petitioner? Two petitioner. However, both the petitioners are ready and willing to contest the case by appearing before the Senate trial court below, if any interim protection is provided to them. Mr. Sharma, the learned litigation PP, submitted in this regard that finding sufficient incriminating materials against both the petitioner, the charge sheet was filed, and charge sheet was filed along against them. So we further submitted that during the period of investigation, both the petitioners did not cooperate in the investigation, and for which only they were shown as an absconder in the charge. Mr. Sharma further submitted that subsequently Section 376D IPC is also charged against both the petitioners, and hence considering the nature of offense, the petitioners may not be provided with interim protection. Next, hearing the submission made by learning counsel for both sides, seen that after that both the petitioners were shown as an absconder in the charge, and the learned trial court below had already issued summons against both the petitioners. However, considering the submission made by learned counsel, both the petitioners are hereby asked to appear before the learned trial court below on or before 15 days from the date of order, and till their appearance, or till 15 days no corrective action shall be taken against him, and the learned trial court below, nothing against him, and would, sorry, them, full stop, both the petitioners will accordingly file a petition for regular bail for the learned trial court below, which may be considered in accordance with the interim protection will be given to automatically stands cancel into violence. And if it doesn't appear within 15 days, the interim protection given to the petition will shall stands automatically cancelled. With the above observation. Oh. Article 29. 29.